FR number. Put it. To appear before the assistant commissioner, assistant commissioner, no? March 11th. Same boss? Yeah? Subsequently, on 4/2/1968, the sale was executed by the mother-in-law of the British on 14/2/1968. Subsequently, the sale data. Sale data. Who sold the property? How? Where is the right? 1970 the regretted one. After connection B. And the sale was executed. Government executed the sale because the mother-in-law is working with her. At that time, government executed the sale. 3 acres, 38 quintals was the land granted. Out of that, 1 acre was executed the sale. In 2 acres, 38 quintals petition is in the sale. So, what was the land granted? 3 acres, 36 quintals. Already one acre executed the sale and 14/2/1968. Subsequently, 12/2/1974, the land was regranted to the petition. Regranted? Yeah, regranted andre? Land granted in 1974. Where is that grant order? That is connection. Page number 19. That is Sagvali cheated. Sagvali cheat connection game. Annexure B also is Sagvali cheat only. Grant certificate. Annexure B is the Sagvali. Lama, you said 74. Again, it was granted. Where is that order? Annexure B, the grant certificate. Grant 1974. 5960 ಅಂತ ಹೇಳ್ತಾ ಇದೆ. Sagvali chit was issued based on which order? ಮೇಲ್ಗಡೆ ಇದು ನೋಡಿ annexure B ಅಲ್ಲಿ ಟಾಪ್ ಅಲ್ಲಿ. You have not reproduced that one in the typed copy. Annexure B ಅಲ್ಲಿ ಮೇಲ್ಗಡೆ there is the number. In the typed copy you have missed it out. Sagvali chit is issued in the year 1992. Grant order is shown as 20 of 1959-60. ಆಯ್ತು ಹೇಳಿ. ಏನಾಯ್ತು ಆಮೇಲೆ? ಹಾ ಹಾ 3 acres 36 ಗುಂಟಾಸ್. ಹಾ ಹಾ ಏನು? ಫಾರ್ ವಾಟ್? Where is that judgment? That declaration as what? That the sale deed. You challenge the sale deed. That suit was dismissed. For what? Yakama, why are you confusing yourself? For what did you approach the assistant commissioner? ಏನಂತ? ಹಾ ಅದು 136 ಕನ್ಸಿಡರ್ ಮಾಡ್ಬೋದಾ? Assistant commissioner, who approached the assistant commissioner? HN? Huh? ಏನಂತ? Assailing a mutation effected in MR number 22 of 2007-2008, affecting the Kata of land, survey number 42. See, he has noticed that you sought for a declaration. Howdo? So when the civil court has declared, what can the revenue authorities do? So therefore, you have to challenge that sale deed in a manner known to law, not before the civil court. If there was a violation of the conditions and sale deed was executed, first of all, you had no right. It was only a temporary sagvali chit. You had no right to sell the property. ಏನ್ ಮಾಡ? Unfortunately, you have lost the case before the civil court. ಏನ್ ಮಾಡಕ್ಕೆ? What can the revenue authorities do? Not under section 136. 136 is only regarding mutation entry. What is wrong in the mutation entry? That earlier mutation entry was based on a registered sale deed. Then the order of the assistant commissioner was correct. Perfect. Learned HCGP. Take notice for response number 1 to 3. Notice to respond number 4 is not necessary for the following reasons. Next paragraph. The petitioner is aggrieved of the orders passed by the Assistant Commissioner, Tumkur subdivision, and the order passed by the Deputy Commissioner, Tumkur district. In proceedings initiated under Section 136 of the Karnataka Land Revenue Act, 1964. Next paragraph. The contention of the petitioner that the land in question, measuring 3 acres and 36 guntas, in survey number 42 of Lakihalli, Kaval, Kasaba Hubli, Tiptur Taluk, was initially granted in favor of Sri Timmanna, son of Timmachari, Timmamma, daughter of Timmachari. So, however, the said grant was a temporary grant for a period of 5 years, commencing from 1958. Full stop. It is contended that one Sri Nanjegowda fraudulently got a sale deed executed at the hands of Timmamma, who was a bonded labor working under Nanjegowda. Full stop. Learned Council contends that when the grant was a temporary grant, Srimati Timmamma had no right to dispose of the property. Nevertheless, a sale deed was executed on 14/2/1968. Stop. However, in the year 1974, the very same land was again granted in favor of Sri Timmamma. Consequent to which, a Sagoli chit was issued on 30th of May 1992. Stop. It is contended that although Timmamma had disposed of only 1 acre of land in favor of Sri Nanjegowda under registered sale deed dated 14/2/1968, nevertheless, Srimati Timmamma, who is the mother-in-law of the petitioner herein, continued to be in possession of the entire 3 acres and 36 guntas of land. Stop. Next, the petitioner herein filed OS number 84 of 1997 before the civil judge, junior division, Tiptu, seeking declaration that the sale deed dated 14/2/1968 is a fraudulent document and it is void in law. And therefore, Srimati Timmamma continued to be the lawful owner of the entire extent of land, including 1 acre, which was sold in favor of Sri Nanjegowda. So, however, the said suit was dismissed. Huh? On 29/7/2002. So, in the year 2007, the petitioner, in the year 2007, the respondent here, the private respondent herein, filed an appeal under section 136(2) of the Karnataka Land Revenue Act of 1964 in RA 47 of 2008-2009, assailing the mutation effected in MR number 22 of 2007-2008, dated 31/5/2008. Entering the name of the petitioner in respect of the entire 3 acres and 36 guntas of land. So, the said appeal was allowed by order dated 5/4/2010. So, the revision petition filed by the petitioner before the Deputy Commissioner from Tumkur district in RP 2 of 2010-2011 was dismissed by order dated 18/11/2019, upholding the orders passed by the Assistant Commissioner. So, next para. Having regard to the undisputed facts narrated herein above, this court is of the considered opinion that no error can be found in the impugned orders passed by the Assistant Commissioner and the Deputy Commissioner. So, both the authorities have held that the earlier mutation entry made in MR number 27 of 6768 and thereafter MR number 27 of 6768 was on the basis of a registered sale deed dated 14/2/1968. So, the subsequent mutation order in MR number 6 of 1994-95 was based on inheritance in favor of the private respondent herein, who is the son of Sri Nanjegowda, the purchaser. Full stop. Moreover, both the authorities have rightly noticed that the suit filed by the petitioner herein, seeking a declaration that the sale deed dated 14/2/1968 is void, has been dismissed by the civil court, and the same has attained finality. Stop. In that view of the matter, this court is of the considered opinion that there is no merit in the writ petition. Full stop. Next para. However, it is open for the petitioner to raise a challenge to the sale deed dated 14/2/1968 in a manner known to law, since it is contended by the petitioner that Srimati Timmamma had no right to dispose of the property, since a temporary grant was only made in favor of Srimati Timmamma, and in terms of the relevant provisions of law, Srimati Timmamma did not derive absolute right over the property in question, and therefore she could not have disposed of the property. Stop. Next para. Accordingly, the writ petition stands dismissed. One not 8K.
To show that identical language. They was granted the
Same learned HCP takes notice for all the respondents. Learned counsel for petitioner is directed to serve a copy of the petition along with annexures from the learned HCP. Next para. Learned counsel for the petitioner submits that under similar circumstances, in WP number 28991 of 2023, this court has not only stayed the impugned order, but has also directed the respondent authorities to restore the revenue entries in the name of the petitioner. Stop. Learned counsel prays for similar interim orders. The copy. Last paragraph, same.
Abhishek K. For the context.
How do you say it is the same?
Identical, same survey number 219. The revenue records are in our name.
What was the new number thought to be assigned? 332. Same orders. As in 1257 of 2024. Dated 25/1/2024. Copy is there. Yes.
Ramu, yes. What's very for the- Private property is declared. You get the property. One is Nishan. In the year 2000, in the year 1930.
Private.
Private property of one Tirungalappa is fitted with one of the caretakers of Anjaneya Swami temple in Chennai. That's a Putteradi, under the registered period of 1930. Entries were continued in the name of Punishami for some time. Thereafter, the entries were standing in the name of Putteradi Anjaneya Swami. But the Archika of the temple, he claims that there was a grant of land in his favor in the year 1975 under the Inams Commission. It's a private property, there is no provision of any Inams Commission, Act 1975. Seeks for an order that his name has to be entered. Matter goes before the Deputy Commissioner. Deputy Commissioner passes a very detailed order saying that there is no such proceedings. That file itself is not there. Whatever he is now seeking to submit is not supported with any other document. Therefore, it's a bogus document, refuses to entertain the same. Then he challenges the orders of the Deputy Commissioner before this honorable. When this honorable court was dealing with the matter, but he raises a contention that in view of the district of Rangareddy district versus Narsingh Rao's case, 1975 is made proceedings, and the entries are now refused to be made. Now they cannot seek to question the genuinity of this order. Therefore, my entry should be made in my name. But this honorable court gave ample opportunities to the state government to file the objections. State government did not file the objections. Taking that the state government objections are not filed, and more particularly notes that the state government also having taken a contention that it's a bogus order. Records it and says in view of the delay and lapses, it is not permissible to accept the contention of the state government and directs the entries to be made in the name of this Archika. Now, he again approaches the Tehsildar. Tehsildar again puts up a report saying that there is no such order, there is no such proceedings, and it's a private land. Where is any question of Inam DC order being passed pertaining to this problem? Now, what is coming in the way is the order of this honorable court, which your losses will find at page number 67, which I am seeking for review.
Who are you?
But we are the devotees. We were the earlier Aspel committee members, and I am the grandson of Munishami. I am the beneficiary of the gift. Listed giftee, and entries were standing in the name of my grandfather Munishami only. Only after 76, 77, membership is changed in the name of Puttenhalli Anjaneya Swami. How I have produced all the RDCs. Your losses go to take page 67. The whole problem for us was what the losses will find at page number.
What is the prayer in the writ petition?
I am seeking for a review of this order 3963 of 2018. Review of Shivdev Singh's case, since all the parties were not met, because then we were the managing committee members.
Learned HCGP takes notice for response number 1 to 4. Issue notice to response number 5 to 9. Learned counsel for the petitioner is directed to serve a copy of the writ petition along with annexures from the learned HCGP.
Now the problem is,
Bari entries no. They are first of all they are objecting. The revenue authorities themselves are objecting. Madakagadilla andu.
but this order still is there. This is a report towards of the Tehsildar. But entries pursuant to the honorable court's order, they have already got the entries. Now they are creating third party rights. But once third party
Civil court.
Because I understand the laws, but here is a case where they are claiming under an order of re-grant set to have been passed by non-deputy commissioner. In respect to the private property, it is another law. And the deputy commissioner specifically said there is no such file, there is no such order.
Let us see.
There will be a lot of status quo regarding the entries at least. Status quo regarding the entries. So the reason why I am saying this, at least if an encumbrance, if this entry is made in column number 11, that there is a status quo regarding the entries. Third party gullible purchases cannot be due. Ultimately, these are the kind of litigations where some third party may become a scapegoat. I am only requesting the losses for direct status quo regarding the entries. Ultimately, it is the proceedings is arising out of the revenue entities.
Is that the prayer in the
Because interim prayer, what I have sought for, it should not create third party rights. They will not grant the revenue. It's a temple property. It's a larger extent of property attached to the temple. Ultimately, some third party should not come. We have a problem. What happens? These kind of third parties, when they come, there are the people who know everything and they try to harm to everyone. Therefore, what's the intelligence of both those at this stage?
by this time we should have gone to the civil court.
But the question of going to the civil court was arising only if the orders of the deputy commissioner was not interfered with by the Honorable Court. The Honorable Court specifically said that there is an order of grant, but once the finding of this Honorable Court is staring at my face, even if I go to the civil court will say that there is an order passed by the High Court that there is a valid grant of 1975. Civil court will be helpless.
No, I don't think this court would have said there is a valid grant.
Can you have a look at that page number? Page 97. Page para 21.
Yes.
It's also related to state here that said that there is no AGS submitted with balance and observations by the institution. Submission is not genuine. Sense submission is not supported by the final statement of connection with regulation. Therefore, mental symptoms is gone against the state with the argument within the evidence. It's finding given. The report is sufficient to ensure that the claim is not accepted.
The revenue authorities, the ಯಾರು ಡೆಪ್ಟಿ ತಹಸೀಲ್ದಾರ್ನೆಲ್ಲ ಪಾರ್ಟಿ ಮಾಡ್ತಾರಲ್ರಿ ತಹಸೀಲ್ದಾರ್ ಮಾಡಬೇಕು ದಿ ವಾಟ್ ಇಸ್ ಡೆಪ್ಟಿ ತಹಸೀಲ್ದಾರ್
Annexure J, page 100, the report which I am relying upon is passed by the deputy principal. The delegation is not, he is the competent authority. That's the reason why we made Annexure J, page 100.
ದಿ ತಹಸೀಲ್ದಾರ್ ಉತ್ತರಹಳ್ಳಿ ಹೋಬಳಿ is directed to enter in column number 11 the pendency of this writ petition before this court, and the revenue authority shall maintain the status quo of the revenue entries as on today. You know, 1999, 99, it has not been considered. Same order, disposed of. ನೆನ್ನೆ ಒಂದು ಬಂದಿತ್ತಂತಲ್ಲಮ್ಮ ಅದನ್ನು ಸೇಮ್ we have mentioned writ petition number 1166 24 ನನ್ನೆದ್ರಲ್ಲಿ ಉಂಟು dated 12/1/2024 ಬಟ್ ನೆನ್ನೆ ಮಾಡಿದ್ವಲ್ಲ ಆ ಟೈಪೇ ಇರಲಿ ಅಷ್ಟೇ ಚೇಂಜ್ ಆಗುತ್ತೆ ಪಾಸ್ ಓವರ್
Ravishankar.
Granted under which provision? Huh?
Index of the land and produce. Thank you for. Also mentioned the cost. Which are produced. Okay.
RTC is still, or RTC is still standing in the name of the temple only. Huh? Huh?
The one gunta out of which you have taken 1 acre, 1 gunta has been named as a crabland, which is reserved for the water stream. I produced the Tiffany in 1961. 822. The title copy is 822. ನಾಲಾ ನೀರು ನೀರು ಆಕಾರ ಬಂದಿರುತ್ತೆ ತಪ್ಪು ಹಾಕುವ ವಹಿವಾಟಿನಲ್ಲಿ ನಾಲಾ ರಾಮಸ್ವಾಮಿ ತಲಕಾಡು that would be one thing I have seen not indicated even in the revenue Tiffany as it is reserved for street. What the Tasildar will do, he take a police assistance to form a road in one gunta. Right say let him to take police. But the notice has produced election he paid 28. And I am turned as an enclosure of the one gunta. Though it has been depicted in the entire revenue record, it is reserved for the water source.
No notice is given to you. No notice.
No, now the JCBs have come and closed this nala. But I produced the photograph, section sheet.
HCGP, AGA. Who is this sixth respondent?
He is the private property purchase for his benefit they want to farm.
Huh?
For the benefit of sixth respondent who has purchased the adjacent property, they want to farm the road by using this part. That is why I made it a farm. I avoided the repetition and in the subsequent purchase. That smooth since with all these actions have been.
Learned AGA takes notice for response number 1 to 5. Issue notice to respond number 6. Learned counsel for petitioner is directed to serve a copy of the writ petition along with annexures on the learned AGA. It is a private temple or a Mujrai temple? Private temple. Who is the owner?
But the Narayan from the temple itself and the Pradhana Archana of that temple.
Sir, it's a private temple.
Yes, correct.
Who is the owner?
But it is standing in the name of the temple only. No building is there.
Huh?
Petitioner is only Pradhana Archana.
How can it be? There should be a managing committee.
Temple granted to you hereditary Pradhana Archana of the temple. That was stated from the reputation that he is a hereditary Archana.
Who appointed you, sir? You are saying it's a Darkhast made in the name of the temple itself. Then how can you claim to be a hereditary archak? ನೀವ್ ಏನ್ ಬೇಕಾದ್ರೂ ಹೇಳ್ತೀರಾ? Contrary statements ಇವೆಲ್ಲ. To serve a copy of the writ petition along with annexures on the learned AGA. Full stop. Next para. ನಾಳೆ ಅವ್ರು ಬಂದಿದ್ದೆಲ್ಲ objections raise ಮಾಡ್ತಾರೆ. Learned counsel for the petitioner submits that it is an undisputed fact, undisputed fact, even according to the record of rights at annexure B1, that 1 acre and 1 gunta of land in survey number 1378 of Talakadu village, Talakadu Hobli, T. Narsipura Taluk, is standing in the name of Sri Vaikunta Narayana Swami Temple, and the name of the temple has been recorded in the revenue records since it was granted to the temple at an undisputed point of time. Stop. The problem, however, is in respect of 1 gunta of land, which according to the Akarband and Tippani, is a water course running in the land in question. Stop. However, at the instance of the 6th respondent, who is said to have purchased the neighboring land, the 3rd respondent Tasildar, T. Narsipura Taluk, has given a communication dated 12/9/2023 to the circle inspector, T. Narsipura police station, seeking police assistance to form a road on the land in question, more particularly in the 1 gunta of land, which is a water course. Full stop. Learned counsel submits that no notice has been issued by the Tasildar before proceeding to issue such directions to the police officers. Full stop. No proceedings have been conducted to declare that 1 gunta of land, which is shown as P. Karab, was earmarked as a road in the village map. Full stop. Next para. Consequently, there shall be an ad interim order of stay of the impugned notice dated 1/2/2024 at annexure K, and all further proceedings thereto till the next date of hearing.
First time,
Lord, I appear for the petitioners, my lord.
Huh?
I appear for the petitioner. In fact, I am instructed to submit office objections have been complied with.
Copy of the order dated 26/9/2022 to be filed as stated at annexure A.
Annexure 26/9.
26/9/2022.
That is the order of the assistant commissioner. It's
ಅಲ್ಲಿ there is a reference to the order of the assistant commissioner.
so what is aside? My lords may kindly see it is Dakshina Vibhaga Bengaluru Madiru RA number 550 bar so and so dated 19 Tahsildar Madida Adesha MRT. My lord, I have produced the MRT itself as 20 bar at annexure E. Tahsildar Madiru Adesha MRT I have produced at annexure D. They want the mutation.
ಅರ್ಜಿಯಲ್ಲಿ ಅರ್ಹತೆ ಇರುವಂತೆ
ಹೌದು.
ಅರ್ಹತೆ ಇರುವುದು ಪ್ರಶ್ನಿತ ಆದೇಶವನ್ನು ನಿಯಮಕ್ಕೆ ವಿರುದ್ಧವಾಗಿ ಮಾಡುವುದು ದೃಢಪಟ್ಟು ಕಾರಣ ಸದರಿ ಆದೇಶವನ್ನು ರದ್ದುಪಡಿಸಿದೆ.
The order of the assistant commissioner is produced, so also the order of the mutation register extract is produced. Assistant commissioner's order, my lord, is at annexure.
Office objection is overruled.
Please,
ಹೇಳಿ.
my lord, the petitioner's grandfather was registered as occupant under the Enams Abolition Act. My lord, in way back in annexure B is the order of the Enams Abolition Order. And my lord, his grandfather was in possession. Thereafter, my lord, the grandfather dies, and then the only daughter of the grandfather is Chaudamma, the mother of the petitioner. We do not know. Suddenly, entries of the names of respondents 4 to 9 come. The petitioner files an appeal before the assistant commissioner. Assistant commissioner allows the appeal and passes the order in favor of the petitioner, saying his name be mutated in the revenue records. Immediately thereafter, they file a civil suit, which my lord,
why you had to go before the assistant commissioner?
Because their names were entered in the revenue records, the respondents 4 to 9. So therefore, my lord, the moment the order of assistant commissioner is
To
passed,
set aside MR number 7 of 7879,
yes, sir,
8 of 7879, so and so.
which we were not aware of, because my
How
grandfather.
can you say you were not aware of?
My grandfather.
7879.
No, my grandfather was looking after the property, my lord.
ಹೌದು, but mutation order is of the year 1978-79.
So, my lord. Then, my lord, the assistant commissioner called for the records and finds out that the order is incorrect. Set aside that order. The moment that order is passed, kindly see, my lord, annexure F, they file a civil suit. They know very
That
well.
kind of a long delay.
Please.
He cannot condone such delay and go on passing orders.
No, why I am only
aside entries which were there standing for more than 30 years.
The respondents are aware.
More than that, for 40 years.
Yes, my lord, I quite see what my lord is saying. Now, my submission is the respondents are aware of the illegality. The moment the AC passes the order, kindly see annexure F, my lord, they file a civil suit in 2022. Annexure F, page 40. They themselves file a civil suit against me, and kindly see the prayer which my lords would get at ink page 53. Ink page 53. To declare that they are the absolute owners in possession of the suit schedule property.
Yes.
And for injunction to declare the gift deed executed by me in favor of my wife as illegal, and
Yes.
for injunction.
Yes.
The suit is pending, and when the suit is pending, they file a revision petition before the deputy commissioner. Ironically, the deputy commissioner, instead of saying that now that you have gone before the civil court, please prove your case and establish your right, the deputy commissioner, my lord, records the fact that there is the civil suit, which my lords would get at the ink page 22 in the impugned order.
Yes.
And records that there is a suit pending, and then set aside the order of the AC.
Yes.
When once a suit is filed, my lord, I hardly need to reiterate before lordship the full bench judgment in Jayamma's case, where their lordships say.
But you could not have gone before the assistant commissioner and got the mutation entry which was there from 40 years. Set aside. ಆಗೋದಿಲ್ಲ.
I quite see what my lord is pointing out, my lord. But in the facts.
That is why the deputy commissioner has set aside the order of the assistant commissioner and said anyway the suit has been filed. As and when the declaration is made by the civil court, accordingly the revenue entry should be made.
No, my lord.
But the mutation entry which was standing for 40-50 years could not have been tampered with.
My only submission before your lordship is.
Yes.
No, my lord, this suit will get the insofar
as only of the year September 2022.
Yeah,
order has been passed by the assistant commissioner.
Houdu. In fact, The assistant commissioners in
Please await the outcome of the civil suit.
But your lordship may observe that the entries effected pursuant to the order of the deputy commissioner will not be binding
No,
on
no.
the civil court.
Order of the assistant commissioner cannot be sustained because it has been done after 45 years.
Please, my lord. But then the order, none of the revenue entries, my lord, the Honorable Supreme Court in JMS.
We can only say that the
Please.
civil court shall decide the case on merits and not give undue weightage to the revenue entries.
Please.
That is all.
Please.
Berkeley. The petitioner, it is agreed of the impugned order. A. Number 396 of 2022. Stop. Next para. Learned senior counsel Shri K. Suman, appearing on behalf of the petitioner, submits that it cannot at the hands of the private respondents herein that by order dated 18/12/1959, 3 acres and 32 guntas of land in survey number 42 of Ekondanahalli village, Sarjapura Hubli, Anekal Taluk, yeah, 1959.
Special DC Mysore Personal and Miscellaneous Abolition Act, my lord. My lord wanted the date, my lord.
The date is there. In whose favor it was granted?
In favor of the grandfather of the petitioner. That is
ಯಾವ್ದೋ ಬೇರೆ ಹೆಸರುಗಳು ಬರ್ತೀನಿ ಸಿನಾಪ್ಸಿಸ್ ಅಲ್ಲಿ.
Synopsis.
ವಾಜಿದ್ ಖಾನ್, ಸತ್ತಾರ್ ಖಾನ್ ಏನೋ ಬರ್ದಿದ್ದೀರಾ?
Allah, they were the earlier inandars. Kindly see the item number 2. Petitioner's grandfather Sri Chaudappa alias Muni Chaudappa was in possession. On coming into court, Chaudappa Munisha filed application for occupancy rights. And Deputy Commissioner in 18 bar, item number 4, really, Deputy Commissioner has granted occupancy rights in favor of petitioner's grandfather Sri Chaudappa alias Muni Chaudappa.
So this 18/12/1959 should have come in column number 4.
I'm sorry, my lord. I also noticed that the synopsis ಎಲ್ಲ ತಪ್ಪು ಬರ್ದಿದ್ದಾರೆ ಸ್ವಲ್ಪ.
Was re-granted in favor of Sri Chaudappa, the petitioner's grandfather, by orders passed by the Special Deputy Commissioner for Inam's abolition, Bangalore, in case number 18 of 1959. So, it is contended that the name of the petitioner's grandfather was entered in the revenue records and the petitioner has succeeded to the land in question. Stop. However, when the petitioner sought to get the revenue entries mutated in his name, to his surprise, he found that the name of the private respondents herein were entered in terms of mutation orders in MR number 8, 9, and 10 of 1978-79. Stop. Feeling aggrieved, the petitioner filed an appeal invoking section 136 bracket 2 of the Karnataka Land Revenue Act, 1964, before the Assistant Commissioner, Bangalore South Subdivision in RA bracket A, close 550 of 2018-19. Full stop. The Assistant Commissioner, having considered the rival contentions, passed an order on 19th of September 2022, setting aside the mutation entries of the year 1978-79 and the subsequent mutations made in the year 1995-96 and 2017-18. Stop. However, the Deputy Commissioner, in the revision petition filed at the hands of the private respondents herein, has passed the impugned order, setting aside the order of the Assistant Commissioner, even after noticing the fact that the respondents have filed, the private respondents have filed OS number 1392 of 2022 on 13/12/2022, seeking a declaration and cancellation of the gift deed dated 26/9/2022 executed by the petitioner herein in favor of his wife. Learned senior counsel would submit that question of disputed title cannot be gone into by revenue authorities, which is a settled position in law. Stop. Next para. For contra, learned counsel for the contesting respondent would submit that the Deputy Commissioner has rightly considered the fact that the revenue entries were made in favor of the contesting respondents way back in the year 1978-79, and the same continued till the order was passed by the Assistant Commissioner. Stop. In that view of the matter, the learned counsel for the private respondents would submit that no infirmity can be found in the impugned order passed by the Deputy Commissioner. Stop. Next para. Having considered the rival contentions and on perusing the petition papers, this court is of the considered opinion that the Assistant Commissioner could not have entertained the appeal filed at the hands of the petitioner herein, challenging a mutation entry made in the year 1978-79 and the subsequent mutation entries made on the basis of inheritance and such other claim by the private respondents who have said to have succeeded to the land in question. Full stop. Delay of more than 45 years could not have been condoned by the Assistant Commissioner. Stop. The Deputy Commissioner is right while holding that the Assistant Commissioner could not have entertained such an appeal, and although a suit has been filed at the hands of the private respondent seeking a declaration of title and cancellation of the registered gift deed, nevertheless, the revenue entries should have been maintained as they were prior to the orders passed by the Assistant Commissioner. Full stop. Next para. Needless to observe that as and when a declaration is made by the civil court and finality is attained, the person who is successful is entitled to have his or her name entered in the land records. Full stop. Next para. Let's explain. The civil court should, however, pass orders on the merits of the matter and not give undue weightage to the revenue entries. Full stop. Consequently, the writ petition stands dismissed.
Disposed ಅಂತ ಹೇಳ್ಬಿಡ್ತಾವ. ಡಿಸ್ಮಿಸ್ಡ್ ಅಂದ್ರೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡಿಸ್ಪೋಸ್ಡ್ ಆಫ್ ಅಂತ ಹೇಳ್ಬಿಡ್ತಾವ.
Yes.
Oblige. I'm sorry, I'm on VC, my lord. My leg is hurt. That's why.
No, it's all right.
Office objection for third time. V.V. Sidramania.
Finally, a week's time is granted at the request of learned counsel for petitioner for complaints of office objections.
Number 12, non-compliance for fourth time. The parties have been dead before the land settlement. The parties have not been made as a reference in the order. And filed an application.
Court fee. Court fee is not paid.
Application number.
Iದ್ರ ಬಗ್ಗೆ parties ಬಗ್ಗೆ have you put up a note in the cost title? ಇಲ್ಲ. ಮಾಡಿದೀರಾ?
Including the applications which have been made.
Who are the parties? The week's time is granted at the request of learned counsel for petitioner for complaints of office objections.
Non-compliance for ninth time.
Matter is called out. There is no representation for the petitioner. 13. This is the 9th time that the matter is coming up for non-compliance of office objections. Stop. Release this matter on 19th of February 2024. Stop. If office objections are not complied by the next date of hearing, this writ petition will be dismissed.
October matter. Number 3.
It was granted to Muthu Krishna. in the year 1966. 2006.
Serial number 3, column number 3. To Inspira, Integra, and Mostro. Para A, para B,
ನಿಮ್ಮ ಸಿನಾಪ್ಸಿಸ್ ಅಲ್ಲಿ you have stated 5 acres and 4 acres 9 guntas was granted in favor of R.K. Muthu Krishna.
But I think that our name should be entered in the Karnataka register.
ಅಲ್ಲ ಅಲ್ಲಿ ನೀವು ತೋರಿಸಿದ್ದ RTC ಅಲ್ಲಿ ಮುತ್ತು ಕೃಷ್ಣ ಬೇರೆ ಇದ್ದಾರೆ. Who is R. Chandra?
R. Chandra is the present petitioner.
How is he related to this Muthu Krishna?
He has
Purchased 4 acres and
sale deed is there. Sale deed is at page 25.
4 acres and 18 guttas purchased. Sorry.
The important point is the board A, 4 acres, D is 29. When I find the repetition for anything by name in the Karnataka register, page 75 plus 4 is to the direction. Page 75. He filed a contempt petition. In that contempt petition, they filed a report. Report what they did was the A was converted into beta.
This complaints affidavit, page number 77.
Page 77 is the complaint affidavit. That along with that affidavit, they said that they have complained with and produced the sketch at page 81. On page 81, that the table plots second, fourth, and fifth total extent matter, but what they did was they divided my land into 3 different portions, stored it in 3 different places. And what they did was they put A Kara, what was the artist, was converted into 4 B Kara, page 9.
2, 4 and 5, 3 separate pieces. But all are separate pieces are
A Kara was converted into 4 B Kara in that order. Order of page 97. order. And as per number DDL number 26 खराब extent of 3 acre fencing होगा to record and enter as B खराब, that is A खराब is now converted into B खराब. Number 26 bar 1 the A खराब extent of 3 acre fencing होगा to record and enter as B खराब and issued order. What was the 3 acre fencing होगा shown as A खराब? They made it into B खराब. Then what we did, taking away by the plan. Here sketch is also there. They are now changed.
ಓದಿದ್ದು ಪೇಜ್ ನಂಬರ್ 96 ಅಲ್ಲಿ. Extent of 3 acre 50 mutas to record and enter as B crop. Good orders. Survey number 26 is coded. Part number 78 is separated. The account is Is there any rival climate? What is the difficulty? Huh?
the entire schedule page. What they have done is they have constructed three different figures. Second one portion, 4 one portion, 5 one portion. All three. This may be compared with the previous year. Is that page 38. The last blocks are in this was one single block. This entire block was not as one block, so it belongs to me. This is separated into the different pieces that is here and here. What was the shown as the digital?
Survey number 26. ಆಕಾರ ಬಂದಂತೆ ಈ ನಂಬರಿಗೆ 4-9 ಖರಾಬು ಇದ್ದು ಈಗ ಹಾಲಿ 1ನೇ ಹಿಸ್ಸೆಯಲ್ಲಿ ಪೂರಾ 4-9 ఉంటే ఖాయం ఇదే.
According to this, is politics. Particularly, if you are to get it in pay, whatever. The entire system is on.
Learned AGA takes notice for response number 1 to 3. Allah, see, the land was granted in the year 1966 to Mr. Muthu Krishna. 2006 ಅಲ್ಲಿ, in terms of the schedule in the sale deed, it's a one piece property. Obviously, they would not like to buy 3 separate pieces. Since it was found that 4 acres and 18 guttas are available in one block, they have purchased that property. He has sold that property as a one block. Now, for what reason it has been shown as 3 separate portions, and how is the question. There is no rival claimant here. Then what is the difficulty? Who are you are the respond number? Respond number 6 yaru? Sangha? When it was granted to them? Early, let them come. We will consider their contentions also, and thereafter issue necessary orders. Learned Counsel Sri N.R. Jagdishwara is requested to take notice for respond number 4. Issue notice to respond number 5. Learned Counsel for petitioner is directed to serve a copy of the writ petition along with annexures on the learned AGA, learned Counsel for respond number 4 and learned Counsel for respond number 4. You want to take out hand summons? In addition, the petitioner is permitted to take out hand summons to respond number 5. ಏನ್ ಮಾಡ್ತಾರೆ ಈಗ? There shall be an addendum order of stay of the impugned order. Impugned orders as prayed for. Come on till the next date of it.
Orders, serial number 55.
is called out. There is no representation for the petitioner. Steps have not been taken for service of notice on respondent number R4A. Finally, a week's time is granted to do the needful. So release this matter on 13th of February. You've taken. You've taken steps. Have you taken steps? When? Last Friday. After that, learned counsel for the petitioner submit that. ಮೊನ್ನೆ ತಗೊಂಡ್ರದು 2ನೇ ತಾರೀಕು. Learned counsel submits that steps have been taken on 2nd of February. Full stop. Office to verify and issue notice. If they are not interested, you leave it, sir. What can we do? Steps have not been taken. In respect of many of the proposed respondents. So this is the 4th time that the matter is coming up for taking steps. Stop. Finally, a week's time is granted to do the needful. Full stop. Release this matter on 13th of February 2024. If steps are not taken, the writ petition will be dismissed. ಅಷ್ಟು ಜನನ್ನ ಇಟ್ಕೊಂಡು ಅವ್ರನ್ನ ಬಿಟ್ಬಿಟ್ಟು ಬಿಕ್ಕಿದವ್ರ ಮೇಲೆ ಹೋಗಕ್ಕಾಗತ್ತಾ? ನಾಟ್ ನೆಸೆಸರಿ. I have given you a week's time. Take steps. Otherwise, I will dismiss the writ petition. ಸ್ಟೆಪ್ಸ್ ತಗೊಳ್ಳೋದಕ್ಕೆ ನೀವು ಲೆಟರ್ ಬರೆದ್ರೆ ನಾವೇನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ? If you have no instructions, leave it at that. Yes. We don't remove the names of the learned counsels like that. Unless the party himself comes here and says, okay, I'll make alternative arrangement. I don't remove the names of the advocates like that. Yes.
Serial number 17, my lord.
They have to make some alternative arrangement. Otherwise, court will have to issue notice to them. We are not going to do that. Yes.
I appear for petitioner in serial number 17, my lord.
16. We are at 16. Request of learned counsel for petitioner for complaints of office objections raised on IAS number 1 to 3 of 2024. Yes. Insofar as respondents number 20 and 22 are concerned, learned counsel submits on instructions that respondents number 20 and 22 are alive, and therefore a wrong submission was earlier made before this court. Full stop. The said submission is placed on record. Yes.
17, my lord.
Yes.
My lord, in respect of respondent number 14, I have taken steps, my lord. As far as
Yes.
respondent number 18, my lord, I have instructions to submit that he is no more, and respondent number 17 is his brother, my lord. As it could be seen from annexure M, my lord, page number 45.
You will have to file necessary application or memo, whatever.
During the course of the day, I shall be filing it.
Whether respondent number 17 is the only legal representative,
Yeah.
we do not know.
My lord, I have been instructed to submit that he died issueless as a bachelor. Respondent number 18. I shall be filing the memo, my lord, to that extent. During the course
That's
of the
all
day.
right, sir. Even if he has died issueless, you should say who are the legal representatives. Whether respondent number 17 is the only person, you will have to say so.
I shall be filing a memo, my lord.
Yes, yes. Please do it.
And may I submit, my lord, respondent number
It is
3, 4,
matter
and
of the
5.
service notice on respondent number 14. Full stop. In the meanwhile, steps shall be taken in respect of deceased respondent number 18. Yes.
My lord, respondent number cast list does not indicate that respondent number 3, 4, and 5 have been served, my lord. May I request the honorable court to reissue the notice to them.
The petitioner shall also take out fresh steps for service of notice on response number
3, 4, and 5, my lord.
3, 4, and 5. ಯಾರು ನೋಡ್ರಿ ಅದು ಅಫಿಷಿಯಲ್ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಏನದು?
Private respondents, my lord.
All right.
Published.
Let's go down. Not, I mean, this is the opposition for kind of opposition of the norm. Because there were 3 items involved. In former, presently, 1 item was petitioner does not make the opposition.
Huh?
3 items involved. 3 is covered.
ಸೊ ಆತರ ಏನು ಇಲ್ಲ. ವಾಂಟ್ ಡಿಲೀಟ್ ಇಟ್, ಡಿಲೀಟ್ ಇಟ್ ಅಷ್ಟೇ. ಹಾ, please give a copy. We'll consider. Let it be served. You want to make submissions on the merits of the matter? Yes. They do not want to press it. They do not want to press the writ petition in respect of one item. That's why we are not considering that submission. We will consider it along with the main matter. ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವಾ ಅವ್ರಿಗೆ? ಯಾವ ಮೆಮೋ ಅದು? Counsel for the petitioner is requested to serve copies of the memo dated 25/1/2024 on the learned counsel for the contesting respondents. Huh? And copy of the memo dated 31/1/2024. Yes. ಎರಡಿರೋದು ಎರಡನ್ನು ಕೂಡ ಕೇಳಿದ್ದೀನಿ. Yes. You'll have to make submissions on the merits of the matter, not this one. If you are ready and they are ready, we will take it up. Release this matter on 13th of February. Learned counsel for the petitioner submits that the amended cost title is ready. Full stop. The learned counsel may file the same in the office. Yes. Yes. Barley, but Learned Counsel for the petitioner has filed a memo dated 24/11/2023 seeking leave of this court to withdraw the writ petition as not pressed. Stop. Next para. The memo is taken on record subject to all just exceptions. Stop. Accordingly, the writ petition stands dismissed as withdrawn.
One. You want to make- Based on my application. Okay, so I had an application to complete. Objections are justified by 5 and 6.
Not served a copy on Learned Counsel for the including applicant in IA number 1 of 2022 is requested to serve a copy of the application on Learned Counsel for the petitioner has served a copy on the Learned Counsel for petitioner today. Full stop. Learned Counsel for the petitioner seeks for a short accommodation. Release this matter on 13th of February. Yes. 13th of February. You want it on 12th? 12th. Finally, a week's time is granted at the request of Learned Counsel for petitioner for taking steps for service of notice on response number 2 to 4. When Learned Counsel for the petitioner submits that steps have been taken this morning, full stop. Office to verify and issue notice. Huh? You are appearing for whom? Respondent. Please come this side. You have to take steps for respondent number 5.
There was a directive to.
No. ಅದು ಆಗೋಯ್ತು ಹಳೇದು ಜುಲೈ ಅಲ್ಲಾದ್ರೆ. You will have to take fresh steps. A week's time is granted. So you are the contesting respondent.
So Arpa did not appear before she in either. Other party. Extent of the land after the.
Sir, you want to undertake to file wakalat for respondent number 5, you undertake. Huh? So what? Tomorrow, see, they do not want to take that risk. If they want to take that risk, they can make that submission, but not at your instance. You want to take notice, you please take notice. Otherwise, they'll have to take steps. Learned Counsel. Ashok R. Kalyan Shetty, who on record for respondent number 4, undertakes to file wakalat for respondent number 5. Full stop. A week's time is granted to do the needful. Release this matter on 13th of February. 13th, 14th, 16th, 16th, huh? 16th of February.
Check action against the deputy commissioner policy. Whether it will be clear or consequences. Chief Secretary.
Yes. Huh? Huh? This matter had come up. It had come up earlier, is it? ಅಲ್ಲ ಅದು ಅದಾದ್ಮೇಲೆ ಬಂದಿತ್ತಾ ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾರೆ ಹಾ
And my lord, just the letter which the deputy commissioner saying that don't grant. After this order, after last order, my lord. Sorry, last the guidance. The communication of the deputy commissioner. My client saying that the earlier application filed by you for conversion.
You know?
The application filed by you. That's the final application. Submitted according to their direction.
Sir, if there is a contempt, you know what you should do. We are only concerned about the action taken, and we had directed the court, the state, to file a complaints report. ಅಷ್ಟಕ್ಕೆ ಬಂದಿರೋದು ಅಷ್ಟೇ ಮ್ಯಾಟರ್. If there is a subsequent violation of the orders passed by this, court, then you will have to go file a contempt. Sir, I have deprecated the action of the officers. What more can I do?
Again, you are rejected.
So you go file a contempt and see that they are hauled up and
Communication must be given.
ಏನು ಯಾಕೆ ಹಿಂಗ್ ಮಾಡ್ತಾ ಇದಾರೆ? What is this?
Page number 10. We say that in the government to take that.
Huh?
Page number 10. 10 page number 9 and 10.
Hmm.
ತದನಂತರ 9 ನಾನು ತದನಂತರ ಉಲ್ಲೇಖದ ಪ್ರಸ್ತಾಪಿಸಿದ ಕೈಗಾರಿಕೆ ಪ್ರಾಧಿಕಾರ ತಡೆಯುವ ಸರ್ಕಾರದ ಅನುಮೋದನೆ ಆಗುವ ಮಾನವ ಯೋಜನೆ ವಾಣಿಜ್ಯ ಕಾಯ್ದೆ ಅಧಿಕಾರದ ಅನುಮೋದನೆ ಕುರಿತಿನ ಪ್ರಸ್ತಾಪಿತ ಜಮೀನಿನ BMSP ಯೋಜನೆ 2 ಟೌನ್ಶಿಪ್ ಪ್ರಸ್ತಾಪ ಬೆಂಗಳೂರು ಲೋಕೋಪಯೋಗಿ ಪದಗಳು ಮತ್ತು ಒಳನಾಡು ಜಲ ಸಾರಿಗೆ ಇಲಾಖೆ ನೈಸ್ ಸಂಸ್ಥೆಗೆ ಮಾಡಿಕೊಂಡಿರುವ ಒಪ್ಪಂದ 3.5.2ರಂತೆ ಸರದಿ ಪ್ರಸ್ತಾವನೆ ಹಿಂದೆ ತಿಳಿಸಲಾಗಿದೆ. ಹಾಗಾಗಿ ಬೆಂಗಳೂರು ಮೈಸೂರು ಕಾರಿಡಾರ್ ಲೋಕೋಪಯೋಗಿ ಇಲಾಖೆ ಕ್ರಿಯಾತ್ಮಕ ಉತ್ಪಾದನಾ ಪ್ರಕ್ರಿಯೆ ಸಂಬಂಧಿ ಕರ್ನಾಟಕ ಪ್ರದೇಶ ಅಭಿವೃದ್ಧಿ ಮಂಡಳಿ ಲೋಕೋಪಯೋಗಿ ಇಲಾಖೆ ಸಮಕ್ಷ ಪ್ರಾಧಿಕಾರವಾಗಿರುವುದರಿಂದ ನಾವಲ್ಲ ಪ್ರಸ್ತಾಪಿತ ಜಮೀನು ಸಂಬಂಧಿಸಿದ ಪ್ರಕರಣವನ್ನು ಲೋಕೋಪಯೋಗಿ ಇಲಾಖೆ ಹಂತದಲ್ಲೇ ಸೂಕ್ತ ಕ್ರಮಗಳಾಗಬೇಕಾಗಿದೆ. ಅದರಿಂದ ಸತ್ಯಪ್ರಕರಣ ತಾವು ಲೋಕೋಪಯೋಗಿ ಇಲಾಖೆಗೆ ನೇರವಾಗಿ ಮಾಹಿತಿ ಕೊಡಲಾಗಿದೆ.
ಲಾಸ್ಟ್ ಕಾರ್ಯಕ್ರಮ ದಯವಿಟ್ಟು ಪ್ರಸ್ತುತ ಉಲ್ಲೇಖ ಮತ್ತೊಮ್ಮೆ ಪ್ರಸ್ತುತ ಜಮೀನುಗಳನ್ನು ಕೈಗಾರಿಕೆ ಸಂಬಂಧ ಈ ಪ್ರಾಧಿಕಾರದ ಅಭಿಪ್ರಾಯವನ್ನು ಕೋರಿ ಅತ್ಯಂತವಾಗಿದ್ದು ಪರಿಶೀಲಿಸಲಾಗಿ ಪ್ರಸ್ತಾವನೆಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖ 10ರಲ್ಲಿ ಸಲ್ಲಿಸಿರುವ ಅಭಿಪ್ರಾಯವನ್ನು ಪುನರುಚ್ಚರಿಸುತ್ತಾ ಸದಿಗ್ಧ ಅಂಶಗಳನ್ವಯ ಪ್ರಸ್ತಾವನೆಯನ್ನು ತಿರಸ್ಕರಿಸಬಹುದೆಂಬ ಅಂಶವನ್ನು what authority they have got? Direct
in this book we have not seen any research area. Any changes in the affair government should take this because it is a frame of government.
No. Why are you writing this communication? ಯಾವಾಗ? This communication is in response to which communication? Where is the response? Where is the reference?
Page number 9.
Plus 10. Reference number
10.
7/7/2022.
11 10 and 11. 11 ಪ್ರಸ್ತುತ ನಲ್ಲಿ ಎಲ್ಲ ಉಲ್ಲೇಖ 11 ಅಂತ ಇದೆ. ಅದಕ್ಕೆ ಮತ್ತೆ ಅವರು ಕೇಳಿದ್ದಾರೆ.
ಎಲ್ಲಿದೆ?
ಅದರಲ್ಲಿ ಹೇಳಿ ಉಲ್ಲೇಖ 11.
ಏನಿದೆ ಉಲ್ಲೇಖ 11 ಸ್ವಲ್ಪ ದಯವಿಟ್ಟು ನೋಡಿ.
ರಿಕ್ವೆಸ್ಟ್ ಐಡಿ ಅಂತ
ಏನಂಗಂದ್ರೆ we are not concerned. You want to interrupt in the course of law, then we will have to take appropriate action. You please file a contempt petition, sir. We are only considering whether the action has been taken in terms of the directions issued. Barkoli. Matter has been listed to consider whether the Chief Secretary, Government of Karnataka initiated action against the 6th respondent Deputy Commissioner in terms of the directions issued by this court, and whether action taken report has been submitted to this court as was directed in the order dated 31st of August 2023. Full stop. Nothing, no report is found to have been submitted at the hands of the Chief Secretary, Government of Karnataka. Full stop. However, learned AGA seeks for a short accommodation to secure instructions and make submissions. Full stop. Release this matter on 13th of February. ತಗೊಳ್ಳಿ ವಾಪಸ್ ಕೊಟ್ಬಿಡಿ ಅವ್ರಿಗೆ. ಸ್ಟೇ ಆಗಿದೆಯಲ್ಲ? ಎರಡು ಕಮ್ಯುನಿಕೇಶನ್ಸ್ ಇದೆ. Correct. Correct. Yes. Huh?
There are some trees. He has enclosed about 30% the fire of the like there is not now that the forest department has come out and said the land is regular. He is claiming on that land. Now that chance the commissioner has also reserved in that lot of resistance from the local saying that he is not going to do
Huh? Yes. Huh? No, no, no. Here grant has already been made. Unless you get it cancelled in a manner known to law, you will not be permitted to do whatever you want. Huh? Statement of objections file ಮಾಡಿ ಅಂದ್ಬಿಟ್ಟು ಯಾವಾಗಲೂ ಆರ್ಡರ್ ಆಗಿದೆ on 1/8/2023. You don't want to file statement of objection, we are not going to force you. On the previous occasion, the learned AGA was directed to secure instructions from the deputy commissioner as whether he would want the Tahsildar to comply with the directions issued by him on 23/2/2023 to issue Sagwali chit to the petitioner or to comply with the impugned official memorandum dated 20/2/2023. So, learned AGA has not secured any instructions from the deputy commissioner. Full stop. Consequently, there shall be an ad interim order of stay of the impugned official memorandum dated 22/2023 and all further proceedings thereto till the disposal of this writ petition. Full stop. Next para. 3 weeks time is granted to the respondents to file statement of objections. Adide, but we had not stayed the impugned official memorandum. List this matter after service of notice on respond number 6. ಇದನ್ನು ಆ ಟೈಪ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದಾರೆ ಫಾರ್ಮ್ ನಂಬರ್ 53. ಹಾ yes yes As
per the record, survey number 1, which as of till today, it exists. Survey number 1, which is a total extent of command land of 40 acres, and their name is the first. Still pending as of today. Survey number 29 is again different land, which is a Torpio land from the year 1962. They don't, they say that both the land are one and the same. That survey number 1, the first name is our petition.
That
application is pending as of today. Regard to survey number 1 for an extent of 1 acre. Subsequently, they say there is a old survey number of 29 number. Old survey number of Illa. As of today, survey number 29 is a coastal land from 1960 till as of today. These are two different aspects which they try to club together. Survey number 29 is there. Up to 1962 in that, I have produced the latest RTC also. Say that it is a Sarkari coastal land.
ಒರಕಲು ಅಂದ್ರೆ
ಅದೇ ಇದು ಸರ್ಕಾರಿ ಅದು ಕಲ್ಲು
ಅದು ಒಂಥರ ವ್ಯಾಲಿ ಆದಂಗೆ ಆಗೋಗಿರ್ತದೆ. ನೀರು ಹರಿದು ಇವಾಗ ನೀರು ಹರಿತಾ ಇಲ್ಲ. ಅದು ದಟ್ ಹಸ್ ಬಿಕಮ್ ಸಮ್ ಸಾರ್ಟ್ ಆಫ್ ಎ ಸರ್ವಿಕ್ಸ್. So according to you, he has filed application in survey number 1. Yes.
As of today, in the name of the petitioner itself, there is 5 acres of land. In his name, he is voting 5 acres of land.
So consider the application rejected. ಮುಗಿದೋಯ್ತಲ್ಲ ಕೆಲಸ. Why are you keeping it pending then? ಏನ್ರಿ ಎಷ್ಟು ಜಾಗ ಬೇಕು ನಿಮ್ಗೆ? Learned HEP submits on instructions that though it is true that the petitioner has filed an application in form number 53 seeking regularization of unauthorized occupation of 1 acre of land in survey number 1 of KG-pura village, the said survey number cannot be confused with the another survey number 29, which is a neighboring property. Moreover, it appears that the petitioner has already been granted 1 acre and 20 quintals of land in survey number 30/5, which is reflected in the RTC. Full stop. ಬರೀ ಅಷ್ಟೇನಾ? 5 ಎಕರೆ.
Moreover, it appears that the petitioner.
One ನಿಮಿಷ. Yes.
Moreover, it appears that the petitioner has already been granted 1 acre 20 quintals of land in survey number 30/5, which is reflected in the RTC.
Which is reflected in the article Sagdaki. Semicolon. 14 guntas in survey number 130/2. 21 guntas in survey number 24/1. 1 acre 7 guntas in survey number 25/2.
When they extend the basin, that was
1 acre 2 guntas in survey number 133/2. And 32 guntas in survey number 131/1. Stop. The learned HCGP submit that the petitioner has got an extent of 5 acres, 5 acres in all, and he would not be eligible for seeking regularization of unauthorized occupation. Stop. Next para. The learned HCGP is requested to furnish all this information to the learned counsel for petitioner. Full stop. Next para. Learned counsel for the petitioner seeks for a short accommodation to secure instructions and make submissions. If this is true, we will dismiss the writ petition and we will direct them to consider your application and dismiss that also. Release this matter on 13th of February. Interim order granted earlier stands extended to the next date of it.
if it's a DC drum.
The liberty to file writ petition, there is a pendency of the writ petition. Learned counsel for petitioner has filed a memo dated 3/1/2024 stating that during the course of these proceedings, the fourth respondent, Assistant Commissioner, has passed an order under Rule 108K of the Karnataka Land Revenue Rules, and therefore the petitioners are now required to raise a challenge to the subsequent order. Full stop. Therefore, it is prayed that the petitioners may be permitted to withdraw the writ petition and challenge the subsequent order. Full stop. Next para. The memo is taken on record subject to all just exceptions. Full stop. Accordingly, the writ petition stands dismissed as withdrawn while reserving liberty to the petitioners to raise a challenge to the subsequent orders passed by the Assistant Commissioner. End document. End certificate copy. ಅದನ್ನೇ ಯಾಕ್ರಿ ಸರ್ಟಿಫಿಕೇಟ್ ಕಾಪಿ ಹಾಕೋದು ಸುಮ್ಮನೆ ಇಲ್ದಿರೋದೆಲ್ಲ ಹೇಳ್ಬೇಡಿ ನೋಡ್ರಿ ತೋರಿಸ್ರಿ why would you file a certificate copy of that grant order? Only in the impugned orders you are required to file certificate copy. Yes.
Please, my lord. I'm appearing for the petitioner, my lord.
Yes.
My lord, petitioner is seeking for direction from this honorable court to consider application annexure B1 and
Please wait.
Not regarding the status, illegal and non-illegal. But the anyone is developed of it, that all the grants are being granted, the employee by state or elected. That's a definition of holding anybody. I think you to everybody there. However, they have some.
They want to dispose of the property. Then AGA submits on instructions that the grant said to have been made in favor of the petitioner. Is said to have been subsequently been cancelled, or an inquiry has been instituted against all such grants which were said to have been made in favor of the displaced persons of the Hemavati Reservoir project. So that is the reason why the computer has been throwing up information declining to permit the sale transaction of the land in question. So next para. Huh? But you will have to file an affidavit. Huh?
Well, kind submission, madam.
2 weeks time is granted at the request of the learned AGA to file necessary affidavit or objections to the writ petition. Full stop.
Well,
We
well,
read
kind,
this matter on 20th of February.
My lord, Your Lordship, kindly permit me to appear, my lord, for the petitioner
Ah,
through video conference. The only prayer, my lord, is for a writ of mandamus, my lord, to consider the representation for change of kata as per Annexure C. Annexure C, my lord, is at page 55, my lord, and it has been requested to be approved and permitted, my lord, by the Tahsildar by letter to the Deputy Commissioner at Annexure D on 19/10/23, my lord, page 56. We have succeeded, my lord, before the civil court by filing a suit, my lord, against the government, and the government's appeal is also rejected. Both the copies of which I have produced at Annexure A and B.
yes, Tahsildar also has recommended in terms of Annexure D communication. ಎಲ್ಲ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ, ಏನ್ ಮಾಡಕ್ ಖಾತಾ ಮಾಡ್ಕೊಡ್ಬೇಕಷ್ಟೇ. ಬರ್ಕೊಳ್ಳಿ. the petitioners are seeking a writ of mandamus to direct the respondent authorities, more particularly the Tahsildar, Mysore Taluk, and the Deputy Commissioner, Mysore District, to
Change the Katham.
make mutation entries in favor of the petitioners in survey number 12/1, bracket old number 12, close, measuring 1 acre and 35 guntas, situated at Pootugalli, Kasba Hubli, Mysore Taluk, in terms of the judgment and decree passed by the second civil judge and JMFC at Mysore in OS number 57 of 2010. Next para. The petitioners had filed the suit against the state government, the Secretary, Urban Development Department, and the Deputy Commissioner, Mysore District, seeking declaration and permanent injunction. The trial court held that in view of the provisions contained in Section 3 of the Repeal Act, repealing the Urban Land Sealing Act and Regulation Act, 1999, it was clear that if the possession of the land deemed to have been vested in the state government under Section 3, bracket 10 of the Principal Act, which was not taken over by the state government or any person duly authorized by the state government in that behalf or by the competent authority, are saved. Stop. Consequently, the suit was decreed with costs, while declaring that the right of the plaintiffs and also the possession of the plaintiffs over the suitable property has been protected by virtue of Section 3, bracket 2 of the Urban Land, bracket Sealing Regulation, close, Repeal Act, 1999. However, the state and its authorities filed miscellaneous petition number 63 of 2014, seeking to set aside the judgment and decree on the ground that it was an ex parte order. Full stop. However, the trial court, by order dated 5/9/2023, dismissed the miscellaneous petition to stop. The learned counsel for the petitioners would therefore submit that, having regard to the undisputed facts, when a representation dated 9/10/2023 was given to the Tahsildar, the Tahsildar has made a communication dated 19/10/2023 to the Deputy Commissioner, Mysore District, recommending the case of the petitioner for mutation of the land records in the name of the petitioners. Full stop. Next para. having regard to the facts narrated herein above, this court is of the considered opinion that the respondent, Deputy Commissioner, Mysore District, is duty bound to pass necessary orders enabling the Tahsildar to mutate and enter the name of the petitioners in the land records as was recommended by the Tahsildar. Stop. Next para. Consequently, the writ petition stands disposed of with a specific direction to the Deputy Commissioner, Mysore District to pass necessary orders enabling the Tahsildar, Mysore Taluk to proceed and enter the names of the petitioners in the land records in respect of the land in question, as expeditiously as possible and at any rate within a period of 2 months from the date of receipt of a copy of this order.
Much of that.
The interlocutor application. 31 is on.
Ah. Ah.
Subsequently, my lord, the next A is a notice. The petitioner had given a statement way back in 1986 by the excess of land. This is the first time. Second ground, the small number of people was missing in the file. 3 years after the grant, inquiry is opened. However, my representations to the Tahsildar and the authorities have been from 1986 itself, page 27, 28 of these minutes. Also valuated land and said the value of the tree is 30,000. Even that 30,000 was also free. All the relevant records are produced before the Tahsildar. Not only that, form number 53, a checklist is open. Page number 37 is checklist. Even the checklist are produced. But still, they are not seeking to cancel the grant on the sole ground that form number 53 is found missing. And this, they find it missing 3 years after the grant is made. Now, as a page, the last NX that I produced newspaper reports. Page 80 to 85. Right for the what has happened? The grant is made. The form number 53 which were filed by these people, 50 lines were granted. They were all taken away from the file. Fresh entries are made because no new applications can be given after the due date is over. And the same is filed and subsequently grants are made. Now my application has been considered and has been granted to me. Now 3 years later they said your application, your form 53 itself is missing. Now after the grant is made, I cannot be said submit all the documents based on which your grant is made. Based on these grounds, I have challenged the writ petition.
You come on the notice.
I've challenged the notice.
Ah.
Yes, 3 years after the grant is made, without giving any reason as to why during the time of the grant they did not, because checklist is prepared, checklist is filed before the tribunal, the Tahsildar is the ex-officio member.
All this you'll have to go and submit before the assistant commissioner.
I've submitted everything to the assistant commissioner. Not ready to consider. My last annexure B.
Well, how are you saying that he is not ready to consider?
Orders
Any orders are passed?
were passed. Orders were passed. They were said for form number 53. The form number 53 is missing. You can't make the applicant as a partner because it is a Tahsildar. Again, he says to bring the form number 53 itself.
No, but even as per the newspaper reports, the documents have been taken into custody by the police.
That investigation is still pending.
So therefore, until the investigation is concluded and the police come to a conclusion as to whether the allegation being made by the revenue authorities now is correct or your allegations are correct, we will not allow him to proceed with the matter. We will say, let him hold on till the investigation is concluded. Has been passed.
As in past, I challenge this proceedings. Assistant Commissioner said, let him consider that order of the police before my first. What I'm saying, I'm not saying.
Huh?
What I am trying to convey.
The Assistant Commissioner has passed orders now.
Assistant Commissioner's order, first round was passed. I challenged before the Deputy Commissioner. The Deputy Commissioner said, if a form number 52 is missing, that is the duty of the revenue inspector to inspect and not the petitioner. So you can't find fault with it. If at all, if you say he has in possession of 2.5 acres of land, that aspect you might look at. But the assistant, the Tahsildar reopens the proceedings. The Assistant Commissioner reopens the proceedings and he says to produce a form number 53. I said, my form number 53 is filed in the counter. You have the checklist which says I have put in form number 53. Now I have put the application for early credits. Again, my last in 2015, they have called for the application for regularization. Now, my last, I have made another representation because now they have said form number 53 is missing.
No, then you will be giving up your valid ground and losing the earlier grant. I don't know, it is up to you.
Is that new application is considered like that, what I got some protection. Because I have even appeared before the investigation officer and said, please give me the copies of the documents. Because I want to see if my application has been forged, because my application is missing. If someone else has taken my application, the investigation officer says, I cannot ascertain it because documents have been heavily forged, everything has been erased.
Have you filed a statement of objection? You will have to first give information as to what happened to the investigation. That was commenced in the year 2015 itself, isn't it? Barkale. Even in terms of the newspaper reports at Annexure S, it is clear that the relevant records, such as the register maintaining the applications filed in form number 53, and what is 56? 57. 57 have been seized at the hands of the police. Stop. The AGA is directed to secure information as to whether the investigation has been concluded and what is the finding of the police. Stop. Next para. The basis on which the proceedings are initiated under Rule 108K of the Karnataka Land Revenue Rules, 1966, against the petitioner is that he had not filed form number 53, and many such persons have been granted lands, although they had not filed applications in form number 53. Full stop. Therefore, it would be relevant to find out as to what is the outcome of the investigation undertaken by the police. Full stop. Next para. Release this matter on 13th of February. Interim order granted earlier stands extended till the next date. Huh?
I was already granted the land. After my grant is made, that form number 53 has been taken out.
That's what, sir. Not only you. It may be many other persons. We do not know. Yes. Yes. Okay. Learned AGA submits that although the survey could not be conducted on 31st of January as was directed by this court, nevertheless, notices have been issued to all concerned, and it appears that the survey is being conducted today. Full stop. Next para. Release this matter on 13th of February to enable the learned AGA to submit the report. Huh? 14. Yes.
Yes, grant was made, sign a grant in 1984. But how it has not been improved, and it has not been. Then almost see the order is 4-1 for pathway. 4-1 before my. Not correct for the same. Correct for the same that by an order is 394. Then get the order, grant 9 acres of land, in favor of Devarai, and 5 acres land in favor of leave distribution on the Devarai. Written hearing things turn of Devarai. To verify the original grant register, issued the only way in which we follow the claim, which is the land. That's what it was listed on.
To secure the original grant register and issue register. Huh?
My lord, in fact, after my lord's order, I himself filed an application for certified copy of the order again, cancel the record. They also face the HM grounds submitted. Along it was again original. It is there. Original grant order. We have again obtained the certified copy from the office of the Deputy Commissioner itself. And so again issued certified copy.
There.
The additional document filed on 22/1. IA number 124. The additional grounds my lord mentioned. The first ground is first para is after my lord order. We again applied for certified copies. And if the document can again burning.
Annexure AL.
Oh.
Huh?
Up to AL, my lord. The annexure yes, my lord, is the grant order. The certified copy is again granted as per annexure AF, page number 15. And that's why it's annexure AC, my lord, page number 10. 10, my lord. Again, I granted a certified copy. This is AC is a copy of yes, on which we are relying upon.
Javaraya Guruswamy.
So this order original document is even now found in the office of the Deputy Commissioner. The ground on which they refused the petition by lord on the ground that original document is not found in the endorsement. Now original document, original Sakoli, this order itself is found in the office of the Deputy Commissioner. All the documents are there. The recommendations made by Rashila. Kindly go to the list itself prepared by me. I will not put the document. List prepared by me. The list, my lord, page number 1. First document.
And next para. Learned senior counsel. Sri P.P. Hegde, appearing on behalf of the petitioners, would submit that subsequently a memo along with additional documents and grounds has been filed before this court on 22nd of January 2024. Full stop. Attention, this court is drawn to Annexure AC, and it is submitted that on 8/1/2024, the respondents have again issued a certified copy of the grant order. Where it is clear that 9 acres were granted in favor of Sri Javaraya and 5 acres were granted in favor of Sri Guruswami. Stop. The learned senior counsel would therefore submit that the contention of the respondent authorities that there is no such records showing the grant, be demolished by the fact that the very same authorities have issued certified copy of the grant order. Stop. Release this matter on 13th of February 2024. Full stop. The learned AGA may either secure the original grant register or make submissions having regard to the certified copy issued by the respondent authorities. Other certified copy of the grant order. Yes. Objections. You want to file objection? The learned senior counsel, Sri Uday Holla, appearing on behalf of the petitioner, would submit that the petitioners may require 2 days time to go through the impeding application filed in IA number 1 of 2024, and thereafter submissions will be made. Stop.
However, the stay has been granted with respect to survey number 138 also. It is specified it only for.
We'll have it on 13th next week. Release this. Release this matter on, you want it on 8th? Huh? 8th of February. You want it on 13th, that? Huh? Allah, anyway, it can be clarified by next week. Want it on 13th? 12th, huh? 13th of February, yes. Yeah. Petitioner number? Second petitioner? Has been filed. Yavaga? 2nd February. Then a counsel for the petitioner submits that an interlocutory application has been filed. Bring on record the legal representatives of deceased petitioner number 2. So, office is directed to put up the application. Release this matter on 13th of February.
In Bigu. 36, in Rumesha.
Ah. Yeah, 2010 ಇಂದ ನಡೀತಾ ಇದೆಯಲ್ರಿ ಇದು. 2010 there is a writ petition. Annexure H. ಓದಿ paragraph number 2. ಇಲ್ವಾ? Huh? Matter is called out. There is no representation for the petitioner. Release this matter on 13th of February. Huh? At 2:30. Huh? Deputy Commissioner. Huh? Huh? Bangalore da? Mysore. Huh?
Brains of them is there existing. I don't know. They say on the village map.
They are challenging the order of the Deputy Commissioner. It can be challenged before whom? Huh? But this is of the year 2014. Yes. Yearly, but it's a small issue. She is having some difficulty in the afternoon, she says. Yearly. It's a simple matter, sir. You please tell us what is there in this.
The purchasers have approached the bank.
Yes. Who formed the layout? Is it a sanctioned layout? Then huh? ಇರ್ಬೋದು. But if it is found that the constructions are put up on the then existing stormwater drain, it has to be cleared. ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ. We have passed this kind of an order even in respect of Bangalore city.
This is different. It was increased by 25 feet subsequently. Nevertheless, these people who are called as authorities, they are already there. They are construction. They are living there comfortably. Particularly,
how do you say what was the original width of the stormwater drain?
Nothing to do with the Halla. Halla is entirely different. Otherwise, on paper, 25 feet actually it is not so. I will demonstrate before the next. That is the reason why I sought for them. Every day that is convenient to you.
So, Anil Babu, you had taken time. Sorry, if you are so sure, you should have come up with the documents. This was filed in the year 2014, and probably no such ground is raised. You are now ಹೊಸ್ದಾಗಿ ಏನಾದ್ರು you are seeking to raise a different ground.
Correctly, I will make this statement. I've got all the documents in my with me. I will review it for your lordship's pleasure. You know, so kindly peruse those documents and finally take a decision. That's my submission.
At the request of the learned counsel for the petitioners, release this matter on 13th of February.
Meanwhile, we find to amend the ground to the Lord, say, we have raised the Lord.
Not now. Source here. You bring it, we'll see.
Not done by her. Where this compound drain exists. That is the reason the photographs have been filed in July 20.
It has been filed. But if it is available, then you can make the argument. We will have it on 13. Yes. Yes.
38, page number 68. 38, Radha in the row.
Granted.
And Karnataka releases in 1981. Back in year 1981. They are similar. Premium has been paid. Form number 10 has been paid. And mutation has been made in favor of the commitment. And in RTC record, his name has been. They suddenly mirror in the year 2014. Government released the name of Amir Khan and showed the name of
By which order?
No order. They are not conducted legally, but under statute. Because Amir Khan's name is there. And all these plans are in custody of every department. They know that our friends have been there. The existing name is there. Inquiry ought to have been conducted, statute they are not conducted in simply they did. And petitioner was not. This Amir Khan, he died in the 2008. Thereafter in 2014, this Wazir Ahmad, who had tried to petition, he opposed the revenue. My father was dead, entered my name. And at that time, they said, he produced all the records that are available to show that the land is granted. All the records are produced. Despite producing all these records, the Deputy Commissioner issues an official memorandum purporting to exercise his authority under Section 71 of the Land Revenue Act, saying that this land I am reserving for house, which did not have done. 71 specifically says the land must be in the government, which could not be in the occupation of any lawful occupation of anyone. But here the land belongs to Amir Khan, and he could not reject the property at all. So suddenly, they advertised in newspaper saying that we are going to conduct traffic. We were not aware of this action in Rwanda, which had been the point because we ain't back petition that has been done. Then immediately we challenged that the order the item which is from the newspaper. Then that is what is happening in the action memorandum also. Thereafter, we have filed amendment application. produce that actual memorandum. That amendment of state is also followed. If your lordship says the order pass variance, he says you have no records. Can you see the actual memorandum? Yeah. Because that's not the decision. I have find it all application. So, okay. With an IAC amendment, I have heard that.
Yes.
I have that. I find that.
Yes. Yes.
492 rupees. 4 Whatever is been allowed to get given and ಬಗ್ಗೆ ಯಾವುದೇ ಇರುವುದಿಲ್ಲ ಈಗ ಇದು ಅಮೆರಿಕ ಹಾಗೂ ಮಾನ್ಯ ಇವತ್ತು ಯಾವುದೇ
You filed a suit. You filed a suit
I filed a suit Narayan after because he was
against.
the original owner who was now he was entertaining it. He also confided to the land tribunal. He was interfering. Then I filed a suit. That's
7 of 2002.
yes, sir.
Where 7 of 2002.
Yes, sir.
Ah.
I filed the in the suit that is decree.
Ah.
ಎಲ್ಲ ನಮೂನೆ 7ಗೆ ಎಲ್ಲ ನೋಟಿಸ್ಗಳು ಪರಿಶೀಲಿಸಲಾಗಿ ಇವುಗಳ ಸಂಖ್ಯೆಗಳು ಒಂದಕ್ಕೊಂದು ಹಾನಿ ಇರುವುದಿಲ್ಲ ಹಾಗೂ ವ್ಯತ್ಯಾಸವಿರುತ್ತದೆ. ಸರಿ ಜಮೀನು 81 ಸಾಲಿನಲ್ಲಿ ಮಂಜೂರು ಆಗಿದ್ದಲ್ಲಿ ಇವರು ತಂದೆ ಜಿಲ್ಲಾಧಿಕಾರಿಗೆ ದಿನಾಂಕ ನಮೂನ 7 ಸಲ್ಲಿಸುವ ಮಂಜೂರು ಅವಶ್ಯಕತೆ ಇರುವುದಿಲ್ಲ. We have not filed any form of 7A. It is another Nagama. There is no record before Nagama Act. For Nagama, they have produced one document along with state of protection. There is no necessity to file form number 7A because all the operations have been granted. It is Nagama who has filed the application. And they discussed to say that you have filed it. ಸದರಿ ಜಮೀನು ಸಾಲು ಮಂಜೂರು ಆಗಿದ್ದಲ್ಲಿ ಇವರ ತಂದೆ ಜಿಲ್ಲಾಧಿಕಾರಿಗೆ ನನ್ನ ನಮೂನೆ 7 ಸಲ್ಲಿಸುವ ಮಂಜೂರು ಅವಶ್ಯಕತೆ ಇರುವುದು ಹಾಗೂ ಈ ಬಗ್ಗೆ ಮಾನ್ಯ ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಅರ್ಜಿದಾರ ತಂದೆ ಅಮೆರಿಕ ಸ್ಟೇಟ್ ಅವರು ಶೇಷಾದ್ರಿ ವಿಜಯ ನಾರಾಯಣ ದಾವೆ ಮಾಡಿ ಶಾಶ್ವತ ಪೊಲೀಸರಿಗೆ ವಾಯ್ಸ್ ನ್ಯಾಯಾಲಯವು ಅರ್ಜಿದಾರ ಪರ ವಾದಿಸಿ ಪ್ರಸ್ತಾವಿತ ಜಮೀನು ಸರ್ಕಾರಿ ಜಮೀನು ಅರ್ಜಿದಾರ ಅಥವಾ ಸರ್ಕಾರದಲ್ಲಿ ಮಾಡಿದ್ದು ಮೇಲ್ಕಂಡ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಎಲ್ಲ ಆದೇಶಗಳು ಸೃಷ್ಟಿಸುವ ಕುಟುಂಬ ಎಂದು ಎಲ್ಲ ಕಾರಣದಿಂದ ಅರ್ಜಿದಾರ ವಿಲೇಖಿಸಲಾಗಿದೆ. ಪ್ರಸ್ತಾವಿತ ಜಮೀನು ಆಂಜನೇಯ ಸ್ವಾಮಿ ಜಮೀನು ರಾಜ್ಯವಾಗಿ ಎಲ್ಲ ಇಲಾಖೆಗಳು ಸರ್ಕಾರದಲ್ಲಿ ನಿಲ್ಲಿಸಿತು ಅದು ಬರಬಿಟ್ಟು TCS and reserving power, exceeding power and exceeding power. Kindly see.
What documents have you furnished?
You will also kindly see Annex A. Is one. This is the order of the land tribunal in favor of this America. Opulence have been granted. Then kindly see Annex B. only 10 had been issued. Thereafter, you have to kindly see. Mutation has been effected. Kindly see equal 19. Annexure C equal 19. This is mutation made with the revenue authorities themselves. They specifically mention that Kolar Karnataka, ನಾವು 20% ಮಾಡಿ ಯಾವುದೇ ತಾಂತ್ರಿಕ ಬಂದಿಲ್ಲ. ಈ ಕಡೆ they refer to proceed ಕೋಲಾರ ತಾಲೂಕು ಕರ್ಬಾ ಹೋಬಳಿ ಜಮೀನು ಭೂಸಾರದ ಕೋಲಾರ ನಿವಾಸ ಅಮಿತ್ ಜಾನ್ ನೀವು ಎಲ್ಲರೂ they refer to this proceeding.
Yes.
And make a mutation also in the year 1981 itself. Thereafter, you will have to kindly see. I have produced annex D equal 50. RTC 21. RTC is the name of Amit. Thereafter, you will have to kindly see this Amit job. I have put death certificate. He died on 27/3/2008. English 24.
Yes.
Thereafter, his son, Wazir Shah, who had filed the petition originally, now he died and his wife and daughter have come on the card. Wazir Shah, he submitted an application saying that my father is dead, make him treatment. I said, yeah. Either. Applicant would be then annex here, they give me this certificate. Say that you could do all. Kindly see next annexure equals to 7. I have received all these documents. 18 documents there will be has received all these documents. All the documents that we got. Then suddenly there is a paper. So when a deputy governor has no jurisdiction, allot this land at section 71. Kindly say 71 of the land.
Yes. Yes, that is clear.
Yes.
Yes.
So it is not a government land at all. When I produce the government, you are not produced. In fact, I have produced all the government.
Where the judgment and decree?
Judgment and decree. Same invitation. Okay. 34 annex L. Page 34. I have made a copy.
It was an ex parte order, is it?
Yes.
Huh?
Yes.
Ex parte order.
All the documents that are referred to. Here referred, here okay. And in favor that against that original.
Yes.
And we also in the land in the law.
Yes.
He appears to put land and this is the
We are not concerned with that.
yes.
We are only concerned with the subsequent action
Yes.
on the part of the revenue authorities in discontinuing the name of your father and putting the name of government. Yes. ಬೇಡ ಅದ್ ಬಿಡಿ, ಬೇಕಾಗಿಲ್ಲ. We are not concerned with that. There is a mutation order at annexure C. In MR number 260 of 1981-82. And there are RTCs. What do you have to say about? ಏನ್ ಹೇಳ್ತೀರಾ ಅದರಲ್ಲಿ? What have you said about the mutation order and entries in the RTC? Suspicious ಅಂದ್ರೆ ಅರ್ಥ ಏನು? If it is true that this type of a mutation order has been passed consequent to the orders passed by the competent authority under the Enams Abolition Act. How could you discontinue the name of that person without issuing notice to him and without conducting proceedings in accordance with law? Simply suspicious ಅಂದ್ಬಿಟ್ರೆ ಆಗೋಯ್ತಾ? What would you say about your own revenue entries? Mutation register ಅಲ್ಲಿ if this kind of an order is found consequent to form number 10 being issued. For the municipality ನೀವಾ? Urban Development Authority.
Attention, we inform them that the proceedings are pending before the council. At this juncture, we cannot consider the application only after the.
Yes, your claim will come to the picture only if the contents of the petitioner is held to be invalid. That kind of proceedings have not been undertaken by the Deputy Commissioner. We'll have to allow the writ petition. The Deputy Commissioner will have to reconsider the claim of the petitioner for entering his name in the land records as he has succeeded to the estate of his father, in whose favor order is said to have been passed by the Enams Abolition Special Deputy Commissioner. Land Revenue. All right, we'll pass orders at 2:30. It on the other side. I don't adjourn the matters unless the other side is here and says no objection. We will see at 2:30. Yes.
ಹೇಳಿದ್ರು ನಾವೇನೋ ಹಾಕಿದ್ದೀವಿ ಅದನ್ನ ಮೂವ್ ಮಾಡಿದ್ವಿ ಪೋಸ್ಟ್ ಮಾಡಿದ್ರೆ ಅವರು ಅಲ್ಲಿ ಆನ್ಸರ್ ಮಾಡ್ಕೊತಾರೆ ಅಂತ ಹೇಳಿದ್ರು. ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ರೆ ನಿಮಗೆ ಬರ್ತದೆಯಾ? ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ರೆ ನಿಮಗೆ ಬರ್ತದೆಯಾ? ಒಂದನೇ ನಂಬರ್ಗೆ ಎರಡಕ್ಕೂ ಹೇಳಿದ್ದಾರೆ. One second. ಅದನ್ನ ಪ್ರಾಬ್ಲಮ್ ಇದೆ ಸರ್. ಅಲ್ಲಿ post ಮಾಡ್ತಾರೆ ಬ್ಯಾಂಕ್ ಹಾಕೋದು. download and repeat ಆಗುತ್ತೆ. ಸರಿ
Number 49. Current counsel for the petitioner has filed a memo dated 6/2/2024 seeking leave of this court to withdraw the writ petition. As per the memo is taken on record subject to all just exceptions. Accordingly, the writ petition stands dismissed as withdrawn. But there's another inform agal. They have to be here. Yes. Eva. For the petitioner 41.1. You are for point 41. 41.2. ಇನ್ನೊಬ್ರು ಇದ್ದಾರೆ. We will see. Yes. Petition number ಇದೆ.
ರಿಪಿಟೇಷನ್ ನಂಬರ್ ಬಂದಿದೆ ಸರ್, ರಿಜಿಸ್ಟರ್ ಮಾಡಿಸ್ಬೇಕು.
ಹಾ,
ರಿಜಿಸ್ಟರ್ ಮಾಡಬೇಕು. ರಿಜಿಸ್ಟರ್ ಮಾಡಬೇಕು. ಅವಾಗ ಅವ್ರಿಗೆ ಪ್ರಾವಿಷನ್ ಇದೆ.
ಹಾ,
ರಿಜಿಸ್ಟರ್ ಮಾಡಿಲ್ಲ.
ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಕೊಂಡಿಲ್ಲ.
ರಿಜಿಸ್ಟರ್ ಮಾಡಬೇಕು. ಮಾಡಿಲ್ಲ.
You have to follow the procedure. Otherwise, what can we do? ನೀವು ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಕೊಬೇಕಂತ ಮಾಡ್ಕೊಂಡಿಲ್ವಂತ ನಾವೇನ್ ಮಾಡಕ್ಕೆ? Even now you can do it. Please do it. What the difficulty? Online ಅಂತಂದ್ರೆ it is open anytime. ಏನಂತ ಅರ್ಜೆನ್ಸಿ? ಎಲ್ಲಿ? ಯಾವ ಜಾಗ? ಯಾವ ಊರ್ರಿ? ಏನು ಗೊತ್ತಿಲ್ಲ. Please move it tomorrow. We'll see. Yes.
Number 38.
Petitioner is aggrieved of the impugned official memorandum dated 4/9/2014 issued by the respondent Deputy Commissioner, Kolar District. Stop. Initially, when the writ petition was filed, the petitioner had only produced a copy of the newspaper publication at Annexure H, which was issued consequent to the official memorandum dated 4/9/2014. So, however, subsequently, by way of amendment, the petitioner was permitted to call in question the official memorandum issued by the Deputy Commissioner. So, next para. It is contended by the petitioners that late Sri Amir Jan was conferred occupancy rights in respect of 5 acres and 10 guntas of land in survey number 10 of Sangondahalli, Kolar Taluk and District by the Land Tribunal, Kolar, in proceedings bearing number LRF DVS 310 of 8081. Stop. The respondents therein were Sri Anjaneya Swami Devaru and the Archak of the temple, Sri Narayanachar. Stop. Consequent to the orders passed by the Land Tribunal, form number 10 was also issued on Twelfth 12th of June 1981. So, the order passed by the Land Tribunal is produced at Annexure A, while form number 10 is at Annexure B. So, at Annexure C, the petitioners have produced a copy of the mutation order in MR number 260 of 1981-82, by virtue of which the name of Sri Amir Jan was incorporated in the revenue records, consequent to the order passed by the Land Tribunal. Stop. Copies of the RTC for the year 1995-96 has been produced at Annexure D, which reflects the name of Sri Amir Jan. Stop. It is contended that Sri Amir Jan passed away on 27/3/2008. Stop. His son Sri Wazir Ahmad, who had filed the writ petition initially, approached the revenue authorities by filing a representation dated 18/8/2014, bringing to the notice of the revenue authorities the factum of the death of Sri Amir Jan, and the petitioner sought for mutation entry in his name on the basis of inheritance. However, it was then brought to the notice of the petitioner that the name of Sri Amir Jan was removed from the land records, and the land was standing in the name of inward commercially government. Stop. During the same time, the Deputy Commissioner also issued the impugned official memorandum granting five acres and 17 guntas of land in survey number 10 for the benefit of formation of a layout for distribution of sites to the siteless persons. Stop. Consequently, this writ petition has been filed, calling in question the official memorandum issued by the Deputy Commissioner and the paper publication which was issued consequent to the impugned official memorandum. Stop. Next para. The further development is that the Deputy Commissioner had assigned the function of formation of the layout and distribution of these sites to the Kolar City Municipal Council, and the City Municipal Council approached the Kolar Urban Development Authority seeking sanction of a plan for formation of a layout. Full stop. Stay order ಆಗಿದೆಯಾ? This court. Huh? Had directed the parties to maintain status quo in respect of the land in question. Full stop. Next para. Learned counsel for the petitioners submits that there was no mention in the record of rights as to by which order the name of Sri Amir Jan was removed from the record of rights. Stop. Learned counsel submits that in the impugned official memorandum, the deputy commissioner has in fact noticed the fact that Sri Wazir Ahmad, the original writ petitioner herein, had filed OS number 7 of 2002 before the learned civil judge, Junior Division at Kolar against ಯಾರು ನಾರಾಯಣಾಚಾರ against Sri A.N. Sheshadri, who was the son of the Archak Narayan Rao. So, the deputy commissioner has noticed the fact that a judgmental decree has been passed by the civil court permanently injuncting the defendant from interfering with the peaceful possession of the suit schedule property. Full stop. Nevertheless, without even adverting to the fact that the name of Sri Amir Jan was recorded in the revenue records after form number 10 was issued in his favor, the deputy commissioner has proceeded to issue the impugned official memorandum granting the entire extent of 5 acres and 17 kuntas of land for formation of a layout in the Ashraya scheme. Stop. Learned counsel would therefore contend that it was impermissible for the deputy commissioner to have passed the impugned official memorandum, having noticed the fact that there was a claim at the hands of the petitioner herein, who had contended that the land tribunal had granted occupancy rights in favor of his father, consequent to which his name was recorded in the revenue records. Stop. The land being a private property, it was impermissible for the deputy commissioner to reserve such lands for the purposes of developing sites under the Ashraya scheme. Full stop. Next para. For contra, learned AGA seeks to support the impugned official memorandum on the ground that the records do not reveal the fact that the name of Sri Amir Jan was recorded in the record of rights. Full stop. In the suit filed by Sri Wazir Ahmad, the state or the revenue authorities were not parties to the proceedings. On the other hand, it was only Sri A.N. Sheshadri, the son of Archak Narayan Rao, who was arrayed as a defendant, and therefore the judgment and decree passed by the civil court is not binding on the state or the revenue authorities. Full stop. Attention of this court is also drawn to a statement in the official memorandum that the petitioner herein Sri Amir Jan had filed form number 7A seeking occupancy rights under the provisions of the Karnataka Land Reforms Act. Stop. It is stated that if Sri Amir Jan was granted occupancy rights in the year 1980-81 under the provisions of Yadu? Yadu? Huh? 1955. Then there was no occasion or need for Sri Amir Jan to have filed Form 7A seeking occupancy rights under the provisions of the Karnataka Land Reforms Act. Stop. The learned HCGP would therefore submit that the Deputy Commissioner is right in holding that the documents sought to be furnished by the petitioners are fictitious and bogus documents which would not confer rights in favor of the petitioners. So, next paragraph. Third, the learned counsel for the petitioner, learned HCVP for the respondent state and the deputy commissioner, the learned counsels for the Kolar City Municipal Council and the Kolar Urban Development Authority, and perused the petition papers. Full stop. With the material available on record, it is clear that the deputy commissioner could not have discarded the contention of the petitioners without verifying the original record. Stop. If the petitioners have produced a copy of the orders passed by the land tribunal, comma, form number 10 issued by the special Tahsildar and the mutation register extract bearing mutation order in MR number 260 of 1981-82, comma, the deputy commissioner was duty bound to consider the contentions of the petitioners. Full stop. It was impermissible for the deputy commissioner to simply discard the contentions of the petitioners without securing the original records and considering the same in the presence of the petitioners. Full stop. It is clear that the deputy commissioner has not followed the principles of natural justice. Full stop. The least that was required to be done by the deputy commissioner was to call for the original records and find out as to whether the revenue records bore the name of Sri Amir Jan in terms of the orders passed by the land tribunal. Stop. If that exercise was undertaken and if it was found that no such revenue entries were made and no such orders were passed by the land tribunal, comma, only then the deputy commissioner would have proceeded to grant the land for any other purpose. Full stop. The deputy commissioner not having undertaken these exercise, comma, this court is of the considered opinion that the impugned official memorandum cannot be sustained. Full stop. The provisions of the Karnataka Land Revenue Act or the Karnataka Land Grant Rules would permit the deputy commissioner or any other competent authority to grant government lands to the benefit of certain individuals, institutions, or for public purposes. Full stop. It is impermissible for the deputy commissioner to grant land belonging to a private individual, comma, without acquiring the land or without following the due process of law. Full stop. Next para. For the reason stated above, this court, having been convinced that the deputy commissioner could not have passed the impugned official memorandum, comma, this court proceeds to pass the following order. 1. The writ petition is allowed. Full stop. 2. The official memorandum, impugned official memorandum, dated so and so, passed by the respondent, deputy commissioner, comma, Kolar district, is hereby washed and set aside. Full stop. Next. The deputy commissioner is hereby directed to reconsider the claim of the petitioners. Full stop. The original petitioner, Sri Wazir Ahmad, had given a representation to the Tahsildar to enter his name in the place of his father, Sri Amir Jan, on the basis of inheritance. Full stop. The Deputy Commissioner, having regard to the subsequent developments, who intended to reserve the land in question for a public purpose, shall call for the original records from the office of the Land Tribunal, Kolar, and the original revenue records, find out as to whether the Land Tribunal had passed orders in favor of Sri Amir Jan and whether the land revenue records were mutated in the name of Sri Amir Jan. Stop. If on perusal of all such original records, if the Deputy Commissioner finds that no such entry, no such orders were passed by the Land Tribunal, or no such entry was made in the land revenue records, only then the Deputy Commissioner shall issue an endorsement to the petitioner and proceed to reserve the land for the purpose of formation of sites. Stop. On the other hand, if it is found that the Land Tribunal had indeed passed such an order and revenue entries were made in favor of Sri Amir Jan, then necessary directions shall be issued to the Tahsildar to enter the name of the legal heirs of Sri Amir Jan in the land records. Full stop.
Therefore, because land only then up in the hand, they have to challenge that order.
Which order? ಅಲ್ಲ ಆರ್ಡರ್ ಇಲ್ಲ ಅಂತಂದ್ರೆ ಎಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡೋದು ಅಂದ್ರೆ ಇಟ್ ಬಿಕಮ್ಸ್ ಎ ಬೋಗಸ್ ಡಾಕ್ಯುಮೆಂಟ್. If it is a bogus document, where is the question of challenging it? Sir, if there is no such order passed by the Land Tribunal, where is the question of cancelling it? What you are trying to say is that if there is such an order, they still have an opportunity to get it cancelled. They should do it in a manner known to law. ಅದನ್ನ ನಾನು ಹೇಳಿಲ್ಲ ಅಷ್ಟೇ.
matter. Number 53, number 19. Srinivas Reddy, RV.
Huh? ಆ ಥರದ್ದು ಏನು ಇಲ್ಲ. ಇಟ್ ಇಸ್ ಆಬ್ವಿಯಸ್. ಇದು Odi and Durasta. Three acres, 2 guntas. ಈ ಸ್ಕೆಚ್ ಅಲ್ಲಿ ಈ ಟ್ರಯಾಂಗುಲರ್ ಪೀಸ್ ಬರುತ್ತಲ್ಲ ಅದು ಮಾತ್ರ 3 acres 2 guntas. ಅಲ್ಲ the western portion of the property that is not included here. Only this triangular piece ಹಿಂಗ್ ಬರುತ್ತ ಕೆಳಗಡೆವರೆಗೂ that is 3 acres 2 guntas. ಅದರಲ್ಲಿ ಇವಾಗ 3 ಡಿಫರೆಂಟ್ ಪೋರ್ಷನ್ಸ್ ತೋರಿಸಿದಾರಲ್ಲ ಏನದು? ಎಲ್ಲಿ ಓದ್ತಿದ್ರೆ 40.
So 2A1 to 2A1, 2, 3, 4, 5, 6 is going to belong to the 29.
When was this Odi and Durast done?
It was done in 87. It was done in 87.
Two 2010 ಅಂತಿದೆ ಡೇಟ್.
ನಾವು among the brothers there was a function. That you got this among the brothers. 30 acres was divided among the brothers. It's one of the 29.
5 to 9 are all brothers. Respond number 10 from
the petitioner, father and brother.
So you purchased a different portion, they purchased a different portion. 30 guntas, 30 guntas. Out of 3 acres, 2 guntas.
He purchased under sale dated 22/3/1948.
ಸೊ ಅಲ್ಲಿಗೆ 1.5 acres ಆಯ್ತು ಇಬ್ಬರದು ಸೇರಿ. ಸೊ ರಿಮೈನಿಂಗ್ ಸ್ಟಿಲ್ ವಿತ್ ದೆಮ್. ಎಷ್ಟು ಉಳಿಯುತ್ತೆ ಅವ್ರ ಹತ್ರ? 1 acre 3 ಗುಂಟಾ. This Kodi and Durastat annexure F, page number 40 has been set aside, is it?
Set aside in 19 so far as my land is concerned. Last week I take place 38.
Yes.
The file as against the respondent number 10 lot. The question only regarding the respondent number 10. You must put C. ಪ್ರತಿವಾದಿಗಳು 2 ಈ ಪಕ್ಷಮ್ಮ ರೆಡ್ಡಿ.
So you are not parties to
I was not party to that. She's not, but
you are the party respond number 2 there.
I also what happened.
ನಿಮ್ ಪ್ರಕಾರ ನಿಮ್ದು which is your portion of the property in that sketch?
Rectangular shape control.
2B ಅಂತಿರೋದು 2B ಅದು ನಿಮ್ದು. ಇವ್ ಮೇಲ್ಗಡೆ ಪೋರ್ಷನ್ ನಿಮ್ದು. ಹಾ ಹಾ road is only to the southern side. Only southern side, road is only on the southern side. ನಿಮ್ಮ ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ರಸ್ತೆ ಯಾವ ಸೈಡು ಇಲ್ಲ, ಮತ್ತೆ ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ? You have to accept this one.
Accepting that we have already indicated in this updating government. They try to implement with us in the start of 10.
This person has already given up his right and he is fighting for it. The partition did. ಆಯ್ತು. All right. No. When you have given up all your rights, you are unnecessarily creating trouble here. That's all. Nothing else. ಎಲ್ಲಿದೆ ಸರ್? Where is your contention in the writ petition? Yes. ಯಾವ ಪ್ಯಾರಾಗ್ರಾಫ್? 8.
There was a partition among the speaker and his brother, and in the fifth partition, the land was fallen to the share of petitioner hearing. It is further relevant to submit that after the partition, the petitioner had applied for transfer for the
ಅಲ್ಲ, ಅದಕ್ಕಿಂತ ಮುಂಚೆ you had executed registered sale deeds. There were 2 registered sale deeds. ಅದ್ರ ಬಗ್ಗೆ ಏನ್ ಹೇಳಿದ್ದೀರಾ?
Now in the district one, they are only seeking for a direction to conduct polling in accordance with
ನಿಮಗೇನೋ ರೈಟ್ಸ್ ಇದ್ರೆ ತಾನೆ? That is what we had noticed in the previous order. That was the contention they pointed out. They had said they had drawn the attention of this court to a release deed dated 4/6/1988, executed by the petitioner herein in favor of his brother, Sri D.N. Nagaraju. It is submitted that although the petitioner does not deny the fact that 30 guttas of land were sold under a registered sale deed dated 22/3/1948, and another 39 guttas of land were sold under registered sale deed dated 31/7/1974, nevertheless, in the release deed, the petitioner has released his rights in respect of the entire 3 acres and 2 guntas of land in favor of his brother. Therefore, it is not known as to how the petitioner is claiming right in respect of any portion of the land in question.
I'm not disputing their sale deed. My only contention is
You have given up your rights in respect of the entire 3 acres and 2 guntas of land. So therefore, how are you standing before this court? Is what was contended.
After release, there was a family arrangement and there was a partition among the family members.
So we asked you. ಅದೇನ್ರಿ I can't understand. ನಾನು ಹೇಳಿದ್ರೆ next day you should be able to get the copy of the partition deed. What is this? I have given a week's time. No. No, sir. Let your brothers come. Let them contest the matter, not you. They are not interested. Why are you doing this? Okay? ನೀವು ಕೊಟ್ಬಿಟ್ಟಿದ್ರಲ್ಲ, you have given up your rights in respect of the entire 3 acres and 2 guntas.
ಅವ್ರಿಗೆ ರಿಲೀಸ್ ಡೀಡ್ ಮಾಡ್ಬೇಕಾದ್ಮೇಲೆ ತಿರ್ಗಾ ಪಾರ್ಟಿಷನ್ ಮಾಡ್ಕೊಂಡು ಅವ್ರಿಗೆ ಬೇರೆ ಪ್ರಾಪರ್ಟೀಸ್ ಪಾರ್ಟಿಷನ್ ಡೀಡ್ ದಿಸ್ ಪರ್ಟಿಕ್ಯುಲರ್ ಪ್ರಾಪರ್ಟಿ ವಾಸ್ ಆಲ್ರೆಡಿ ಶೇರ್ಡ್.
Why have you not furnished a copy of the partition deed then? ನೀವು you should have furnished it along with the writ petition itself to show that how you acquired rights. ಅಬಿಡಿ ಒಂದು ವಾರ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೀವಿ ನಿಮ್ಗೆ. You will not even be able to produce a copy of the partition deed. What should we say? ಏನು? Sir, if you have said so in your memorandum of writ petition, why have you not produced a copy of the partition deed?
I think dispute alone on the reason of the but in the meantime I am also not disputing their sale deeds. Whether I am not disputing their sale deeds. Now joint agreement has not put I can't dispute it. My only contention is the OD was not conducted earlier in accordance to the schedule to the sale deed. That is only my contention. Now joint agreement is saying what so I can't dispute their sale deeds. And you are going to dispute what else. The only the fact is our schedule and even recently also our literally what was not conducted in accordance with the schedule and the period. I will produce all those things, my lord. Even now I am not
disputing our sale. What they say now,
now every say deed what
You have not even referred to the date of the partition deed. In paragraph number 8, you have not even referred to the date of the partition deed.
the extent is also not interaction
may make this. Myself and my brother and my father, when we were in joint, always same what is coming in. We are not disputing their sale.
Sorry.
After that sale is remaining ಏನಿತ್ತು ಅದನ್ನ ಅವರು ಬೇರೆ ಸರ್ವೆ ನಂಬರ್ಸ್ ಕೊಟ್ಟು ನನಗೆ ಈ ಸರ್ವೆ ನಂಬರ್ ಬಂದಿದೆ ಪಾರ್ಟಿಷನ್. That is only my contention. Of course, when there is a part on my part, not producing the partition deed. I will certainly. Now,
It cannot be because you have not even mentioned the date of the partition deed, which means it's a oral partition according to you.
It's the part of
Otherwise,
it's the part of the partition deed. Please, my lord.
no, is it possible that you don't even mention the date of the partition deed?
It is already a part in the partition suit only. It is a part of the document.
What was the difficulty for you to produce a copy of the partition? ಅವ್ರಿಗೆ ಹುಷಾರಿರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅಂತ you could have secured a copy. This is not fair.
Please, I'm sorry. I'm here to present. So greatly appreciate. Even the extent is also not mentioned. What they contain is entire 3 acre 2 months is collected.
On the previous occasion, Berkeley, on the previous occasion, this court had recorded the submissions of the learned counsel for the contesting respondents that the petitioner herein had given up his rights in respect of the entire 3 acres and 2 guntas of land under a release deed dated 4/6/1988. Stop. It was therefore contended by the respondents that the petitioner had no right surviving in respect of the land in question, and therefore he could not have approached the survey settlement authorities challenging the Podi and Durust that was done and settled long ago. Stop. At that juncture, learned counsel for the petitioner had submitted that subsequently there was a partition deed. There was a partition amongst the family members, and again the petitioner acquired rights in respect of a portion of the land. Full stop. This court had therefore directed the learned counsel for petitioner to furnish a copy of the partition deed. Full stop. Next para. Learned counsel for the petitioner submits that the petitioner was unwell and therefore he was not able to procure a copy of the partition deed. Full stop. Next para. Release this matter on 8th of February, Nadiddu, 8th of February 2024, to enable the learned counsel for the petitioner to furnish a copy of the partition deed. Let us see. At 2:30 p.m.
This case, other the second respondent.
Huh?
I put the simple aspect word, but there was a direction given by the form previously that the form 7 that the master appeared suspicious and other expert direction for an inquiry to be conducted regarding the genuinity of the said form 7. The land will be contrary to the express order of the court, not of any inquiry, and it just assumed the genuineness and gone on to pass the order. A lot may kindly take up page 115 of the previous order of the court. So absolute right on the issue. Page 115. That's from Roman Femur, WP 216.9 of 2001. Page 115. Petitioner had tried earlier expedition very number also seeking maintenance for consideration of application in form 7. The court allowed the petitioner and directed the tribunal to dispose of the application. The tribunal in the inquiry found that the petitioner has not filed any form number 7. Accordingly, dismissed the claim. The petitioner filed WP 70. This court set aside the order and directed fresh inquiry by giving notice to the landlord. In the third round,
where are you reading?
Page 116. Page 116 top portion. 116.
115 is the order of the land tribunal. Annexure H2.
Annexure H3.
The order of this court ends at page number 114.
Annexure H3.
H3 now. ಇದರಲ್ಲಿ
ಇದರಲ್ಲಿ the petitioner had filed earlier writ petition bearing number so and so seeking mandamus for consideration of application in form number.
ಹಾ
This court allowed the petition and directed the tribunal to dispose of the application. So the tribunal in the inquiry found that the petitioner has not filed form number 7. Accordingly, dismissed the claim. The petitioner filed WP number so and so. This court set aside the order dated 17/9/96 and directed fresh inquiry by giving notice to the landlord. In the third round, the tribunal finds that the petitioner has not filed form number 7 and dismissed the claim. Hence this petition. The land revenue records have been secured. It is now found in the land revenue records that form number 7 filed by the petitioner is available and safely packed with a plastic cover. The learned counsel for the respondent submits that form number 7 in question is a concocted document that on earlier occasions it has been categorically found that there is no form number 7 filed by the petitioner. The endorsement is also issued to the effect by the Tahsildar that the petitioner has not filed any form number 7. Keeping in view the above submission, the order of the tribunal is said, the matter is remitted back to the tribunal to find out whether the form number 7 in question available in the file is a genuine one and is filed within time. If the tribunal finds that the form number 7 is a genuine one, then further inquiry to be held and the case to be disposed of in accordance with law. But this is the express directive given by the Honorable Court. This is confirmed by the also the writ of appeal member. In fact, in the impugned order, the land tribunal extracts this portion of this order, my lords, and just goes on to assume the genuineness of form number 7, saying that the form number 7 is found to be genuine. No inquiry is conducted regarding the genuinity of it, my lords. In fact, the rules under the Land Reform Act, my lords, Rule 19 very specifically said, so the Tahsildar has to receive the application and then send the extract to the land tribunal. In fact, my lords, I have obtained an RTI query as latest as 2023 and 2019, where they say form number 7 is not available even today.
what is this document that was produced before the court?
My lords, they say that there is a form number 7. That is found only when this honorable court summons the original records. It is now conspicuously found in a plastic laminated sheet. There is no endorsement anywhere as to when it was received, how it was received.
So they do not want to give a finding.
No finding is being given.
Yes, what to do? Huh?
ಕುಮಾರ ನಾಳೆಗೆ
ಯಾರು ನಿಲ್ಸಿರೋದು? Huh?
ಚೇತನ್
Learned counsel for the petitioner submits that although this court had specifically directed the land tribunal to conduct an inquiry to find out about the genuineness of form number 7, which was suddenly forthcoming before this court after the third round of litigation. Nevertheless, the land tribunal has not conducted any inquiry. It did not find out or verify from the register maintained in the office of the Tahsildar as to whether there was such an entry regarding receipt of the application in form number 7 at the hands of the contesting respondent herein. Full stop. Next para. At this juncture, learned counsel for respondent number 2 seeks for a short accommodation. Full stop. Release this matter on 13th of February. 12th. Then 14th will have. Huh? There is no special orders. ಯಾಕೆ ಬಂದಿದೆ ಮ್ಯಾಟ್ರು? ಡೇಟ್ ಕೊಟ್ಬಿಟ್ರೆ ನನ್ನ ಮುಂದೆ ಬರಬೇಕಾ? Matter pertains to the land acquisition roster. Is this matter before the bench having roster? Interim order granted earlier since extended to the next date of it. Non date kodalla. I am not giving a date, sir. Yes.
What you want? Mahesh.
At the request of learned counsel for the petitioner in WP number 12594 of 2016, released this matter on 13th of February.
42. British Panigayan.
And has been granted me. Saying that for 25 years I did not alien. That only to that extent.
Huh?
If restriction file, only to the extent of saying that it is not alienated.
Condition being imposed. By?
Because this grant is made. If you get annexed A is the grant. And is page 2. ಮೇಲೆ ನಿರ್ವಹಿಸಿದ ಪ್ರಕರಣಗಳಿಂದ ನಿರ್ಗಮಿತ ಭೂಮೌಲ್ಯ ಸರ್ಕಾರದ ಆವರಿಸಲು ಜಮೀನನ್ನು ಏರುತಿ ಕೃಷಿ ಮೂಲ ಉದ್ಯೋಗಕಾರರಿಗೆ ಸೇರಿದ್ದಾರೆ ಸಂತಾನ ಅಂತ ಹೇಳಿ ಇವರ ಮಕ್ಕಳು ತನ್ನ ಸಹೋದರ ಅಧಿಕಾರನಾದ ಜಮೀನು ಕಾಯ ಮಂಜೂರು ಮಾಡಲು ಕರ್ನಾಟಕ ಭೂ ಮಂಜೂರಾತಿ ನಿಯಮಾವಳಿ 1969 ನೀವು ಅಧಿಕಾರವನ್ನು ಚಲಾಯಿಸಿ ಗ್ರಾಮ ಮುನ್ಸಿಪಿ ತಾಲೂಕು ನೇತೃತ್ವದ ಜಮೀನನ್ನು ಈ ಷರತ್ತುಗೊಳಪಟ್ಟು ಮಾಡಿ. This grant is made under
there is a reference to a circular.
That circular
ಇದಾ ಇದಲ್ಲ. In condition number 4 there, in the same page, ಸರ್ಕಾರದ ಪ್ರಕಟಣೆ ಸಂಖ್ಯೆ RD 30 LGP 2002-11 ದಿನಾಂಕ 23/4/2005
15 ವರ್ಷ 27 ವರ್ಷ. Originally under this rule, the grant has been made.
Yes.
In 1958.
Yes. So I'm asking you for a copy of that circular. If there is a reference to a circular, should you not try to find out what is there in the circular when they have specifically stated so?
There granted rule of only condition ಮಾತ್ರ ಹೇಳಿದ್ದಾರೆ. ಇದರಲ್ಲಿ 15 years ಇದ್ದದ್ದು 25 years.
Correct.
I will produce that.
Since you are calling in question that imposition of such a condition, and when they have referred to the circular, you should produce a copy of the circular. Sir, they have specifically referred to the circular. ನೀವು ತರ್ಸ್ಕೊಳ್ರಿ. Did you notice it there? Baba ilva file ilva? Huh? ನಿಮ್ಮ ಹತ್ರ ಇದ್ರದ್ದು ಇನ್ನೊಂದು ಕಾಪಿ ಇದೆಯನ್ರಿ? ಪ್ಲೀಸ್ ಗಿವ್ ಹಿಮ್ ಎ ಕಾಪಿ. ಯಾವ್ದು? ನೋ, ಅನೆಕ್ಷರ್ ಎ. ಅನೆಕ್ಷರ್ ಎ ಒಂದು ಕಾಪಿ ಕೊಡಿ ಅವ್ರಿಗೆ. ಕೊಡಿ. ನಿಮ್ ಮತ್ತೆ ಲೇಟ್ ಆಗತ್ತೆ ಅಷ್ಟೇ. ಹಾ? Learned counsel for the petitioner is directed to serve a copy of the writ petition along with annexures from the learned AGA. Full stop. Learned AGA is directed to secure a copy of the circular dated 23/4/2005, which has been referred to in condition number 4 of the impugned order passed by the Deputy Commissioner. Full stop. Release this matter on 13th of February. ಯಾರ್ದು? Office objection on the NOC Vakarat filed by learned counsel Shri S. Kalyan Baswaraj is overruled. Learned counsel Shri Kalyan Baswaraj seeks for a short accommodation, since he has come on record only today. Stop. For the petitioner. Full stop. Release this matter on 13th of February. 20th of February. ಏನ್ರಿ ನೀವೇ ಟೈಮ್ ತಗೊಂತ ಇದ್ರಲ್ರಿ ಪ್ರತಿ ಟೈಮ್? Rarely we reach this B group matters. You want to take time. Request of learned counsel for petitioner release this matter on 13th of February.
Aside the order of grant. The order is very kind. Case data. If land is granted to some other person, portion of the land is granted to some other person. If you order, that all the session pass. Meantime, after the final of the situation, what of the Assembly Commission and of the State Commission set aside by the Deputy Commissioner in the page by order 2021/2022, Vision 129 of 19. Therefore, the order of the Assembly Commission setting aside the grant has now been set aside.
Is it you are pursuing two remedies? Is it? You filed this writ petition challenging the order of the Assistant Commissioner.
By filed an petition challenging the order of the deputy commissioner, not annexure A. Order granting the land in favor of some third person. That has been done. Page 16.
2018.
Yes,
30/10/2018.
this order has been passed under the condition. First condition. ಈ ಆದೇಶ Another condition. Now, assistant commissioner was driving before the deputy commissioner in revision petition, and that order came to be set aside by order dated 22 and it was recently. Therefore, the assistant commissioner order does not submit. Therefore, we are the absolute. Not having granted to any other.
Where is that order?
Order of that is, I have released it along with additional documents. Exchange of the additional set of documents in the file subsequent to the filing of the petition.
Yes. ಅಲ್ಲೇ ಅವ್ರಿಗೆ ಹೇಳ್ಬಿಡ್ಬೋದಾಯ್ತು ಡೆಪ್ಟಿ ಕಮಿಷನರ್ಗೆ. ಅದ ಕಾನ್ಸಿಕ್ವೆನ್ಸ್ he has to withdraw that official memorandum ಅಂತ. You didn't bring it to his notice, is it? If the very same deputy commissioner has passed the impugned official memorandum, you could have brought it to his notice. No, you are not challenging it. No. As you rightly pointed out, in the official memorandum itself, a condition has been imposed that it will be subject to the final outcome of the challenge raised to the order of the assistant commissioner. So after this order was passed, you could have simply filed a memo before the deputy commissioner saying that by virtue of this order, the order of the assistant commissioner has been set aside, and therefore that official memorandum also has to go.
Not doing, it is not being done.
Barkali. Learned counsel for the petitioner submits that the impugned order at annexure A was passed by the deputy commissioner, Bangalore Urban District on 30/10/2018, reserving 20 guttas of land. Ashtena?
Yes.
20 guttas of land in survey number 81/P2 for construction of a hostel for the minority students, however, subject to the final outcome of the challenge raised to the orders of the assistant commissioner passed in proceedings bearing number LND/RA bracket 4 A 4 illa bracket A close 4 of 2016-17. Full stop. Learned counsel submits that subsequently in a revision petition filed before the very same deputy commissioner challenging the orders of the assistant commissioner, the deputy commissioner has passed orders on 21st of February 2022, setting aside the order of the Assistant Commissioner in respect of the mutation entry. So, in that view of the matter, it is submitted that the impugned official memorandum cannot be sustained by virtue of the subsequent developments and setting aside of the orders passed by the Assistant Commissioner. So, next para. Accepting the submission of the learned counsel for petitioner, comma, since the deputy commissioner has set aside the order of the assistant commissioner in proceedings bearing number so and so, and the mutation entry in MR number 7 of 1993-94 stands confirmed in the name of the petitioner's hearing, comma, the impugned official memorandum needs to be recalled or set aside. Full stop. Next para. Accordingly, the impugned OM dated 30/10/2018 issued by the Deputy Commissioner, comma, Bangalore Urban District is hereby quashed and set aside.
BS Nagaraj.
Respondent, huh? Matter is called out. There is no representation for the petitioner. Stop. Release this matter on 13th of February.
Even for BS.
Huh. ಯಾರು ಕ್ರಯ ಮಾಡುದು?
I have produced the CID data initially, 1960 maybe ನಾನು ತಂದ್ಕೊಂಡಿರೋದು. Subsequently, my name was entered in admitted first and pursuant to my purchase note Pada everything. If my daughter is kindly take Aniksha A into pay, which I purchased in the year 1960.
Huh.
If my daughter is kindly take first months, right, copy. At page number 21. Okay, copy number page number
21.
Right, copy. Kaya Ashwi Narasimhaya. Ashwi Narasimhaya.
Huh.
So he is the one who has purchased the property.
Hmm.
It is enlarged at field filed, enlarged now filed an application. There is no entrance. Even if my daughter to kindly take page number 27. Page number 27.
ಅಲ್ಲ ಪಡ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಯಾವಾಗ ಮಾಡಿರೋದು?
ವೆಬ್ಸೈಟ್ ಕಾಲಮ್ ನಂಬರ್ 4 ಪಡ ಅಂತ ಅವಾಗ ಕಾಲಮ್ ನಂಬರ್ 21 22 ನಲ್ಲಿ ವೆಬ್ಸೈಟ್ ಪಡ
ಯಾವಾಗ ಮಾಡಿದ್ದು ಅಂತ?
74 75 69 70 ಪರೀಕ್ಷೆ ಈ There is no transaction after 1960 in respect to this plan. And only on an endorsement say that the changes application delayed. And further will also kindly say. Page number 61.
What is that rule 119 of?
Occupancy or alienated holding on payment of finance fees. Deputy Commissioner may refer any forfeited occupancy or alienated holding which has been purchased on account of government and which has not been disposed of or occupied within 3 years from the date of picture of payment of purchase. Picture was good. Together with an amount of land revenue in respect to holding from the date of picture to the date of restoration. And the other expenses incurred in so far as revenue further proceedings as was better. If there will be an order passed by the deputy commissioner to classify this land as a park. My lords are angry there. There should be an order passed by a deputy commissioner to classify it that I have not paid earlier, and this land is classified as a park. Also to kindly take answer
You can't all canvas all those aspects now.
But
see, it's more than 70 years now.
application of
You can't say we do not know whether they have the deputy commissioner has adalla. That is not the issue now. The issue now is whether your application to remove the word pada by collecting the arrears of land revenue can be considered or not. You can't try to question the imposition of the pada in the revenue records, which was done way back in the year 1968. Adagadilla. I have passed orders, but ಇವಾಗ ಇವ್ರು ಏನ್ ಹೇಳಿರೋದಂದ್ರೆ 3 ಸರಿ ಸೇಲ್ ಆಗಿದೆ ಅದಾದ್ಮೇಲೆ ಅಂದ್ಬಿಟ್ಟು. ಐ ಆಮ್ ಓನ್ಲಿ ಟ್ರೈಂಗ್ ಟು ಫೈಂಡ್ ಔಟ್ ವಾಟ್ ಇಸ್ ದಟ್ ರೆಫರೆನ್ಸ್ ಇನ್ ದಟ್ ರೂಲ್. He is referred to that rule. Where is it found? ಏನಿದು ವಾಟ್ ಇಸ್ ಇಟ್ ಏನೋ ಇಷ್ಟ ಬಂದಂಗೆ ಬರೀತಾರಲ್ರಿ. If there is some reference to the rule and he is saying according to that it should not have been sold. ಎಲ್ಲಿದೆ ಹಂಗಂತ? It should not have been sold ಅಂದ್ರೆ ಅರ್ಥ probably without realizing that there are arrears of land revenue and that there is a imposition of this word pada in the RTC. He has subsequently sold it. He has lost right to come back and say no I will pay the arrears of land revenue, so revoke that order anta, because he has already sold off the property. But ಆತರದೇನು ಇಲ್ಲವಲ್ಲ, there is no reference. The person's son is before the court saying I want to pay the arrears of land revenue, please collect it and remove the ಹೌದು ಯಾವ್ದ್ರಿ ಅದು? When is this endorsement given?
This is the internal correspondence for me, endorsement is given on 16/6/2020.
ಎಲ್ಲಿದೆ ಅದು?
The annexure L page 3. These are the internal correspondence between deputy commissioner and the tahsildar and assistant. This is only the endorsement.
Huh?
This is only the endorsement is being given.
ಏನಂತ ಕೊಟ್ಟಿದ್ದಾರೆ?
Because जमीन बड़ा जमीन कंदाय का पाव कंदाय पाव की बड़ा जमीन की सरकार जितना बड़ा नहीं चला है पर आप को लगे तो हमारे एयर भी बड़ा नहीं जमीन के कंदाय पाव की बड़ा ये नोटिस नकल अभी एक्सेल लगे हुए
ಬರ್ಕೊಳ್ಳಿ. The petitioner is aggrieved of the inaction on the part of the respondent revenue authorities in receiving the arrears of land revenue and not removing the endorsement inverted commas pada in the revenue records in respect of survey number 80/2 measuring 1 acre 16 guntas situated at the Kunduru village Kurti Durga Hobli Kunigal Taluk Tumkur district. Stop. Next para. Then a council submits that the petitioner's father, Sri Narsimaya, purchased the land in question under registered sale deed dated 22/6/1960. So, the revenue records were mutated in the name of the petitioner's father. So, however, it is not known as to when exactly the revenue officials incorporated the word pada in the revenue records. Stop. Nevertheless, after the ಏನ್ರಿ ರಾಮಚಂದ್ರ ಸನ್ ಆಫ್ ಲೇಟ್ ಕಂಬಯ್ಯ ಅಂತ ಹಾಕಿದೀರಾ? ಯಾರು? Narasimha is your uncle. How are you claiming? So? What do you mean co-owner? He has purchased it, sir. Huh?
He has purchased of the joint occupancy 1960.
Agadilla. We will only say consider the claim of Sri Narsimaya's legal heirs. If they come forward to pay the arrears of land revenue, it can be collected and the word pada can be removed. Ashte heltini ashte. Not in favor of the petitioner. Ali Narsimaya ಈ ಪಾದ ಅಂತ ಬಂದಿದೆಯಲ್ಲ, ಪೆಟಿಷನರ್ಸ್ ಅಂಕಲ್ ಅಂತ ಬರುತ್ತೆ. ಹೇಳಿದೆ ಆಮೇಲೆ
But it is not known as to when exactly the revenue officials incorporated the word pada in the revenue records. Nevertheless, after
the demise of Sri Narsimhaya, ಇದರ ಇಲ್ಲ Sri Narsimhaya, the petitioner gave a representation on 30/4/2012 seeking to remove the word pada from the land records. Stop. Curiously, the respondent Tahsildar the petitioner has also given representations to the deputy commissioner. Stop. It appears that on a letter, on a communication made by the assistant commissioner, the respondent Tahsildar made a communication dated 19/2/2014 at Annexure H addressed to the deputy commissioner, Tumkur district, that having regard to the mandate contained in Rule 119 of the Karnataka Land Revenue Rules, 1966, the representation given by the petitioner cannot be considered, since there has been 3 sale transactions. Stop. Learned Counsel submits that after Sri Narsimhaya purchased the land under registered sale deed dated 22/6/1960, there has not been any other sale transaction or transfer of the property. Full stop. Therefore, such a factual incorrect information given by the Tahsildar cannot be sustained. Stop. Next para. The Learned Counsel would further submit that this court, in the case of Sri Shivanna versus the Deputy Commissioner and others, in WP number 19639 of 2021, by order dated 5th of September 2022, allowed similar writ petition while considering the provisions contained in Rule 119 and Section 163 of the Karnataka Land Revenue Act of 1964, and consequently held that no time frame is fixed for collection of the arrears of land revenue, unless the forfeited land is otherwise disposed of. Stop. In that view of the matter, the Learned Counsel submits that a direction may be issued to the respondent revenue authorities to enable the legal heirs of Sri Narsimhaya to pay the arrears of land revenue, and after collecting the same, the incorporation of the word pada should be directed to be removed from the revenue records. Full stop. Next para. Accepting the submission of the learned counsel for petitioner, comma, this writ petition stands disposed of while directing the respondent revenue authorities, more particularly the Tahsildar, Kunigal Taluk, and the Deputy Commissioner, Tumkur, to consider the request made by the petitioner that the revenue authorities should collect the arrears of land revenue from the legal heirs of Sri Narsimhaya, and thereafter pass an order of cancellation of the forfeiture bracket pada and remove the same from the revenue records. Stop. The entire exercise shall be completed as expeditiously as possible, and at any rate within a period of 3 months. From the date of receipt of a copy of this order and or within a period of 2 months from the date of payment of the arrears of land revenue at the hands of the legal heirs of Sri Narsimhaya, ordered accordingly. Pass over. It's 4:30. 4:30, madam. At the request of learned counsel for petitioner, release this matter on 13th of February.
Putting in order first, serial number 50.
I am for respondent 2 and 3 in this matter, my lord. I am for respondent.
ಯಾರು ಅದಕ್ಕೆ matter pertains to land acquisition roster. Full stop. Office is directed to list this matter before the bench having roster. Interim order granted earlier stands extended till next date.
Obliged.
Huh? ಏನು ಆರು ಇಂಬರಹ ಹಾ ಏನಿದು
ತಾಲೂಕು ಉದಿಗುಂಟೆ ಹೋಗಿ ಕಡತೂರು ಗ್ರಾಮದ 1984 ಎಕರೆ ಸಮರ್ಪಣಾ ಮುಖ್ಯಗಳಿಂದ ತೆರವು ಮಾಡಿದೆ. ತೆರವು ಮಾಡಿರುವ ಲೇಖನ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಶಿರಾ ತಾಲೂಕು ಪೊಲೀಸರಿಗೆ
Tahsildar has written to the Panchayat Development Officer.
was kindly in respect to this declaring Kavarsan survey number 120, there was no basis. There is no basis. And without exercising eminent domain under the state, the said order was passed by the Tahsildar.
Who are you?
And the owner of the property.
Owner of?
Survey number 120.
120. 120.
Survey number 120 84 ಅಂತ ಕ್ರಿಯೇಟ್ ಮಾಡಿ 1 ಎಕರೆ ಲ್ಯಾಂಡ್ ಕಬರಸ್ಥಾನ ಅಂತ ವಿಚಾರಣೆ ನನ್ನ ಲ್ಯಾಂಡ್
ಓದಿ.
1 ಎಕರೆ ಕಬರಸ್ಥಾನ ಜಾಗವನ್ನು
ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ
ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಶಿರಾ ತಾಲೂಕು ಉಳಿಯುತ್ತೆ ಹೋಗಿ ಕಡತೂರು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 84 1 ಎಕರೆ ಕಬರಸ್ಥಾನ ಜಾಗವನ್ನು ಸದರಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 126 ಕಾಕತಾಳದಲ್ಲಿ ಶ್ರೀ ಮಂಜುನಾಥ ಗೌಡ ಶ್ರೀ ಜಯಕೃಷ್ಣನಾಥ ಅವರ ಸಂಖ್ಯೆಯಲ್ಲಿ ಕಬ್ಬಿನ ಗೇಟು ಅಳವಡಿಸಿ ಒತ್ತುವರಿ ಮಾಡಿಸಿದ್ದು ಸದರಿಯವರು ಮಾಡಿಸಿರುವ ಒತ್ತುವರಿ ಪ್ರದೇಶವನ್ನು ದಿನಾಂಕ 2024 ಗ್ರಾಮಸಭೆ ನಿರೀಕ್ಷಕರು ಉದ್ದೇಶಿಸಿರುವ 6 ಕಲ್ಲಿನಿಂದ ಮತ್ತು ಸಂಖ್ಯೆಯಲ್ಲಿ ತೆರವು ಮಾಡಿದ್ದು ತೆರವು ಮಾಡಿ ಸಾರ್ವಜನಿಕ ಬಳಕೆಗೆ ಮುಕ್ತಾಯಗೊಳಿಸಿದ್ದಾರೆ ಹಾಗೂ ಸದರಿ ಜಾಗವನ್ನು ನಿರ್ಮಿಸುತ್ತದೆ ಸುಪರ್ದಿಗೆ ತೆಗೆದುಕೊಳ್ಳುವಂತೆ ರಾಜಕೀಯ ಕಲದಲ್ಲಿ ತಿಳಿಸಿರುತ್ತಾರೆ. ಅದರಿಂದ ಸರ್ವೆ ನಂಬರ್ 84 ಹೆಚ್ಚಿನ ಭಾಗದಲ್ಲಿ ಒತ್ತುವರಿದಾರರೇ ಅಳವಡಿಸಿರುವ ಸಂಖ್ಯೆಯನ್ನು ತೆರವು ಮಾಡಿರುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ಒತ್ತುವರಿಯಿಂದ ತೆರವುಗೊಳಿಸುವ ಪ್ರದೇಶವನ್ನು ಹಾಗೂ ಸಂಖ್ಯೆಯಲ್ಲಿ ನಿಮ್ಮ ವಶಕ್ಕೆ ತೆಗೆದುಕೊಳ್ಳಬಹುದು. ಈಗಾಗಲೇ ಒತ್ತುವರಿ ಪ್ರದೇಶವನ್ನು ತೆರವು ಮಾಡಿ ನಿಮ್ಮ ಸುಧಾರಣೆಗೆ ತೆಗೆದುಕೊಳ್ಳಲು ತಿಳಿಸುವುದರಿಂದ ನೀತಿ ಮಾರ್ಗದಿಂದ ಸದರಿ ವಿಚಾರದಲ್ಲಿ ಯಾವುದೇ ತೆಗೆದುಕೊಳ್ಳಲು ತಿಳಿಯುವುದು. This excerpt which was started with us from the representation was made by the private respondents of us. Even there is no document, very same process, a page number is also.
ಏನ್ರಿ ಪಂಚಾಯತ್ ಡೆವಲಪ್ಮೆಂಟ್ ಆಫೀಸರ್ ನೋಟಿಸ್ ತಗೊಂಡ್ರು ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಇಲ್ವಾ? Please inform him and ask that they should be represented by learned counsel. Otherwise, we'll proceed to pass orders. But your ಹೆಸರು ಇದೆಯಲ್ಲ ಅದರಲ್ಲಿ. How could the Tahsildar do all this? ಅವ್ರಿಗೇನ್ ಪವರ್ಸ್ ಇದೆ? ಯಾವ ಪ್ರಾವಿಷನ್ ಕೆಳಗಡೆ? If there is a dispute between two parties, private parties, how can the Tahsildar do all this? ಅದೇ ಪಂಚಾಯತ್ ಡೆವಲಪ್ಮೆಂಟ್ ಆಫೀಸರ್. ಪಂಚಾಯತ್ ಡೆವಲಪ್ಮೆಂಟ್ ಆಫೀಸರ್ ಇಸ್ ನಾಟ್ ಗೌರ್ಮೆಂಟ್.
Document there is no document. Even before
Where is the question of eminent domain? What are you talking of? They are saying that you have encroached on some other person's land. Yeah, eminent domain.
Survey number 120 which comes under the Uligunte Kadakuru Gram.
ಎಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀರಾ? Where have you given your objections? Where is the objections that you have given? Annexure?
Representation.
Where is your representation, sir? Yeah, proceedings ಎಲ್ಲ ನಡೆದಿದೆ. ಇವ್ರ ಮುಂದೆ Deputy Director.
Then our. Dismissed now that traffic is pending into area. Meanwhile, the Victor of Command issued this. Or this order.
You have to go to the civil court.
What happened to the last? You fight the suit for injunction before the civil court. The issue is these documents are not before even JDLR or before the civil court. This is the order of the court when the Victor was calling without being any authority and law. That is the question before the last. Because without authority and law, whether Tashikar can pass this kind of order or without being any authority and law. This is the question.
Sir, you yourself are saying there is an order passed by the Deputy Director which is against you.
Incorporation of Survey 84 in Survey number 120 was challenged the Deputy Director. The incorporation of 84 in Survey number 124 it was the challenge before the Deputy Director. That was dismissed. That was challenge before the JDL.
ಸರ್ವೆ ನಂಬರ್ 120ರಲ್ಲಿ ಹೊಸ ನಂಬರ್ 84 ಹೊರಡಿಸಿ ದುರಸ್ತು ಪಡಿಸಿರುವುದನ್ನು ಪ್ರಶ್ನಿಸಿರುತ್ತಾರೆ. ಮೇಲ್ಮನೆಯದಕ್ಕೆ ಕಾಲಮಿತಿ ನಿಯಮ 5ರ ಅಡಿಯಲ್ಲಿ ಪ್ರತ್ಯೇಕ ಅರ್ಜಿ. So it is dismissed only on the ground of delay ನಾ? ಅವ್ರು ಯಾವಾಗ ಬೇಕೋ ಡಿಲೇ ಮೇಲೆ ಹೊಡೆದಾಕ್ತಾರೆ. ಇಲ್ದಿರ 45-50 ವರ್ಷ ಆದ್ರೂ ಪರವಾಗಿಲ್ಲ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಆರ್ಡರ್ ಮಾಡ್ತಾರೆ.
That is my difficulty. Now they are trying to take possession, illegal possession by the Tashikar.
We'll have to go to the civil court.
The civil court.
We are not. How are we concerned with all this? We are only concerned with these revenue records, survey settlement records ಅಷ್ಟೇ. ನೀವು ಬರೀ ಬೇರೆ ಇಂಜೆಕ್ಷನ್ ಸೂಟ್ ಹಾಕೊಂಡ್ರೆ ಏನ್ ಬಂತು?
Page number 41. Order of this honorable court. Page number 40. The respondent not received any action pursuant to Annex 7 and keep for a period of 10 days the date of receipt and the period of the report.
That was only to enable you to go before the joint director. So therefore, you should have filed an interim application before the joint director. Madi, you should have obtained an order. ಯಾವಾಗ ಅದು when was it reserved for orders? 6/12. When it counsel for the petitioners submits that in terms of the liberty granted by this court in WP number 23129 of 2023 dated 13th of October 2023, the petitioners herein have approached the joint director of land records challenging the orders passed by the deputy director of land records. Full stop. Though the petitioners have pressed for interim relief, no orders were passed by the joint director. Full stop. Further, the joint director heard both the parties and reserved the matter for orders on 6/12/2023, 16/12/2023, and no orders have been passed by the joint director. Full stop. In the meanwhile, the Tahsildar has proceeded to take law into his hands and facilitate the erection of fencing for the benefit of the Kadakaluru Gram Panchayat. Stop. This is evident from the impugned communication dated 17/7/2023 at Annexure S. Stop. As regard to the fact that final orders are to be passed by the Joint Director of Land Records, the respondent Tahsildar and all revenue authorities and the Panchayat Development Officer of Tadakaluru Gram Panchayat are hereby directed not to precipitate the matter any further. Stop. Ask them to come and enter appearance. ಅಲ್ಲಿ ಬರ್ಕೊಳ್ಳಿ. It is noticeable that though notice has been served on the Panchayat Development Officer, there has been no representation for the Gram Panchayat. Stop. Learned HCGP is directed to inform the Panchayat Development Officer and ensure that the Gram Panchayat is represented in this matter. Allah. Appeal is provided only when there is an order passed. They is not passed any order. That is the problem here. That is why we had asked you to please find out what is the difficulty. Matter is called out. There is no representation for the petitioner. Full stop. Learned AGA is once again directed to secure instructions from the respondent Tahsildar and make submissions on the next date of hearing. Release this matter on 13th of February.